Okay, I declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the Whistleblower Protection Authority Bill 2025. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. For people participating today remotely, I'm the Chair, Senator Jana Stewart. I'm joined today in person by Senator Claire Chandler, who's the Deputy Chair, Senator Pocock, and online we have Senator Helen Polly. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. Thank you. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage witnesses on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground on which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear. The witnesses should speak clearly and into the microphone to assist Hansard to record today's proceedings. Now, after that spiel, I now welcome Miss Jeannie Marie Blake. Have I said that right, Marie?
Yes, you have.
No? Great. Miss Sharon Kelsey. And online we have Mr Dennis Gentillen.
Sorry, I've got three groups here this morning in this group.
So we've got three witnesses.
Three witnesses, yeah. So you've got who belongs with who's transparency, who's the Griffiths and who's the human rights.
That's the next session.
Oh, that's the next session. Sorry, this is right.
Yeah. So I want to thank each of you for taking time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat as well today. For the Hansard record, would you please state your full name and the capacity in which you appear today? And I might just start on the left.
Yep, I'm Jeannie Marie Blake. I'm a Services Australia employee here under Human Rights. Australian Human Rights Committee.
Sharon Kelsey. I'm here in my personal capacity as a whistleblower.
Thank you. We'll go online.
It's Dennis Gentleman, an advisor to Transparency International Australia, but also a former whistleblower.
Thank you. Would any of you like to make a brief opening statement?
Yes, please. Thank you. Thank you for the opportunity to speak today. I blew the whistle on Robodebt. I experienced firsthand the absence of support for whistleblowers, and that's why I'm firm in my belief that we need whistleblower reform, now including the establishment of a whistleblower protection authority. For most of my career, I've worked for Services Australia. I was on the front line of the implementation of what became known as Robodebt. As I explained in my testimony to the Royal Commission, involvement in Robodebt was a deeply traumatic experience. I tried from the very beginning, when there was a part of an initial program, pilot, to blow the whistle on the scheme. I immediately saw Robodebt for what the Royal Commission eventually concluded it to be: unlawful and deeply unethical. I thought it should be stopped, to never proceed beyond the pilot. But when I and others raised concerns, we were met with a stark message: resign, transfer or comply. The message was as blunt as that: shut up or leave. Our concerns were ignored, and instead we received threatening communications, performance targets, threats of underperformance, code of conduct breaches were used to suppress dissent. Daily emails reminded us that if we were to speak outside our team to anyone about our work, we could be terminated. There was no safe, independent mechanism for staff to report concerns without fears of reprisals. If such a body had have existed, I believe many more staff would have spoken out, and Robodebt may have been stopped before it had even started. Think about what that might have prevented. The trauma avoided, the beautiful lives not lost as a result, and billions in taxpayer dollars not wasted. If whistleblowers were provided protected and empowered, not punished, maybe we could have avoided Robodebt altogether. At its core, Robodebt was a breakdown of integrity. A logical response in such situations is to go outside that system and report somewhere, somehow, some way. While the integrity of all government systems relies on public confidence, there are a range of reasons the integrity of those systems can be compromised. Whistleblowing is a vital safety valve when those systems fail. No doubt you'll hear much today about the importance of whistleblowing and how we can improve support and protection for whistleblowing. But I'd like to speak to you about my personal cost of speaking out. I lost my career, my mental health suffered, I struggled with an alcohol dependency, I became unable to parent properly or care for my elderly parent. I endured suicidal ideation. A decade since I first blew the whistle on Robodebt, and over 2 years since I gave evidence at the Royal Commission, I'm still suffering. I was so traumatised by my experience that I'm on workers' compensation, barely subsisting on a fraction of my former salary. Ultimately, my family and my career have paid the very high price of speaking up. Meanwhile, those most responsible for Robodebt have faced no real consequences. The Royal Commission vindicated those who raised concerns, and yet we still suffer. Society benefits when whistleblowers speak up. Ultimately, Robodebt was stopped, but we're left here on a scrap heap, paying the high price for our sacrifice, a sacrifice that I made in the public's best interest. I'm not the only one. In recent years, there's been Australians prosecuted for blowing the whistle, a whistleblower imprisoned for speaking up. There are dozens of more that have had their careers ended or sidelined for doing the right thing, not to mention those, many like my colleagues during Robodebt, who simply walked away in disgust. For this reason alone, there should be some sort of mechanism for whistleblower support to support whistleblowers who speak up in the public's best interest, to have a body which can offer a modicum of protection, to bring, for those who would bring right to a place where it can be considered, should be at the core of efforts to restore credibility in the Australian public institution. That is why we need Whistleblower Protection Authority. That is why I came here today, to call on the Albanese Government and Attorney General Michelle Rowland to act. Whistleblower protections must ensure those who speak out for what is right are not punished in doing so. The integrity of our public systems depend on it. Thank you.
Thank you. Would anybody else like to make an opening statement?
Yes, thank you. I'm the former Chief Executive Officer of the Logan City Council. In 2017, I made a public interest disclosure. The committee will find my submission as number 49 on your website. The then Mayor of Logan City Council was subsequently charged with a range of offences, and it took until 2023 for the former Mayor to plead guilty to one count of misconduct in relation to public office and failing in his obligation to update his register of interest. He was also facing 1 count of official corruption, but instead pled guilty to the alternative charge of receiving a secret commission by an agent. I've previously been employed in executive at the Victorian Independent Anti-Corruption Commission. For completeness, I'm also a member of the Transparency International Australia National Whistleblowing Advisory Group. I hold a law degree with honours and a Master of Laws. I made my public interest disclosure to the Queensland Crime and Corruption Commission regarding concerns with the conduct of the then Mayor of Logan City Council. Shortly after my appointment, a number of my staff came to me expressing concerns about what they believed was the culture of the conduct of many in the council. I advised them that if they held sufficient information, they needed to make their own public interest disclosure, and that I would in fact form my own view based on an objective assessment as to what I saw. It took me little time to realise that there were significant things that I should be concerned about, and as I said, I took steps to then report that to the Crime and Corruption Commission. As a consequence, a number of events occurred. These included my concerns that my employment was becoming irrelevant to matters where I considered that it shouldn't have been, and I made application to the Queensland Industrial Relations Commission to bring an injunction in relation to the actions. You'll see in my submission there's a fuller version in terms of what the court did. Essentially, it held an injunction in relation to the Mayor's participation, but allowed the Council to proceed with consideration on a number of matters. My employment was terminated in early 2018, although some argued that it was a surprise to them and that they did not make the decision until they entered the council chambers. Subsequent information and also general information that was available at the time knew that it was inevitable. I subsequently lost my position. I have been unable ever since then to secure any sort of commensurate employment. My only recourse was to take legal action myself and to pursue my unfair dismissal based on what I believe was because I made a public interest disclosure. It has been 8 years that I have been involved in legal proceedings. Not only has my family suffered, and I respect what Jeannie has said and concur with the horrendous toll that it takes not just on myself but on those around me that watch me suffer, and of course my immediate family who also suffer in terms of the ramifications, both financial, being the main breadwinner in the family, and also of course having children that I had to put through school. Everybody was and has continued to be under immense pressure. My legal costs have amounted to almost $4 million. They are costs that I have been unable to secure any external assistance with, and most people are staggered with how can legal costs get to the point of $4 million. And the reality is, if you look at the history of my case, I think there's now 17 judgments that have been made through the various court proceedings. And currently, while the court has made a decision that has gone against finding that I was unfairly dismissed, there are still some parallel proceedings that are occurring in relation to the councillors who voted for my termination and the Queensland Government. Suffice to say that no matter how well you might have been placed prior to making a public interest disclosure, it's devastating. Not only in a personal capacity, it impacts all of those around you. It narrows very much the people that you can associate with. Many people were told that if they associated with me, that there would be consequences for them. And so there's not only a withdrawal in terms of those that can support you, but you find that there's very few, certainly institutions, that in any way can support you. The Crime and Corruption Commission, and we know this through a Senate inquiry that was conducted in Queensland, had understood that they had an obligation to protect me as a whistleblower. That Senate committee found that, in fact, they had no such duty and that their duty was, in fact, in relation to investigation of the alleged criminal conduct. I went to any institution that I thought could remotely help, and what I found was that while people may have, and I say may because some people refused to speak to me, while some parties may have essentially provided some support in terms of understanding the challenge, there was no real support in terms of either psychological support, financial support, or general support throughout this issue. And so I relied on my personal capacity and my personal resources to be able to bring legal action for really what I did, which was in fact a public duty. There was no insurance for me, although I understand that there was insurance extended to the Mayor and the councillors that were subsequently charged, and also in relation to their defence of the civil actions against them. This meant that essentially I could only pursue legal means based on the resources that I've had. I lost the family rural property in Victoria, and I've now returned to South Australia, where I have family support and am able to try and piece together, I'll say, some rekindling at best of the life that I once knew. Suffice to say that while I'm one person, I know that there are many people who have experienced similar and traumatising experience of blowing the whistle. And I think the really important thing is, while Jeannie, myself and Dennis are speaking first, that it's really important to remember that the protections are meant to protect people like us, to allow us to be able to speak about injustices and to allow us to be able to right wrong. Thank you.
Thank you. Mr Gentillon, have you got an opening statement? Sorry, you're on mute.
Apologies, Chair.
No, that's all right. It's good for somebody to kick us off there.
Look, I'll try and keep it brief because I'm conscious of time. And it's very sobering hearing those stories because I provide a bit of a contrasting story because my story as a whistleblower was relatively positive. So, the way that I tend to look at things is whistleblowers suffer recrimination from two sources. Firstly, it's the institution that they work for where they make a disclosure and that institution just fails to protect them. That wasn't my experience. So when I blew the whistle when I was at the National Australia Bank, the organisation did a great job of protecting my anonymity. My identity was made public when the matter I disclosed went through the courts a couple of years later. That was around 2005, and I ended up remaining at that institution up until early 2016. Now, look, there are a variety of factors that drove that outcome. I think a lot of it was, accident rather than the design. But what I would encourage the committee to do is to familiarise themselves with the research that was undertaken by the Whistling While They Work program, spearheaded by Professor AJ Brown, which really looked into in some detail what drives positive outcomes for whistleblowers. I think that's a really important work for this committee. The second source where whistleblowers can face retaliation is from the people that are impacted by their disclosure. And there's that famous quote, I'm not sure who you attribute it to, but, judge me not by just the friends I make, but not just by the friends I keep, but by the enemies I make. And all whistleblowers, this statement has really deep meaning to whistleblowers because we make some really good enemies. So I've gone on to have a relatively successful career, but employers that I've worked for have received, anonymous whistleblowing disclosures against me, suggesting that I'm in there, conducting covert investigations and I'll be leaking to the media, etc. These are totally baseless, malicious. They're done to try and, compromise, or sow seeds of doubt in my employer and suggest that I'm a person of questionable character. And I don't share that story to look for pity or sorrow. You hear stories that are far more devastating than mine, as you just have by the earlier two witnesses. But it just brings home the point that when you decide to blow the whistle, inevitably the outcome will be that you will suffer some form of recrimination and retaliation. And that's why it's important we have some sort of authority that helps those, especially those whose stories are far more detrimental than mine. Thank you.
Thank you, and thank you for your opening statements this morning. We'll now proceed to questions, and I'll move to Senator Pocock.
Thank you, Chair. Thank you all so much for being here, and thank you for what you've done for the Australian public. I'm really sorry to hear about how you've been failed and the price that you've paid personally. I'm interested what sort of support would have made your whistleblowing experience better. What did you actually need when you were trying?
I think an independent body.
Yeah.
I don't think. I think at the actual point when Robodebt was being implemented, a lot of the staff were following the directions of those above, and there really wasn't anywhere that you could get any traction to change it. You were told to shut up or leave, and you had to. I was told that if I was going to go and do a public interest, you'd lose your job, you'd have no career. We were all threatened with that, giving out information. It's all under privacy. You breach the code of conduct if you speak badly about public service. But the outcome, you see the loss of integrity in public service, and the public lose faith in that. So I think if you had an independent body where you could go and feel safe, I think you would have had a lot more staff willing to actually speak out at the implementation.
And I'd concur with that. As I said, when I started as Chief Executive Officer, for the first couple of days, I had staff coming regularly to my office raising their concerns, and they felt that they were not able to make their own public interest disclosures. And here I was leading an organisation where I'd come from a platform of integrity, and of course that meant that I was going to, walk my words. I was going to do what I was asking everybody else to do in the organisation. The reality is, as Chief Executive Officer, I almost had less support in the fact that I didn't have the support of, I did have the support of the union, but I wasn't a union member and couldn't be. But the support from the union came because staff supported me. But for me personally, there was really nobody that I could go to. I tried all of the institutions that you would expect, Crime and Corruption Commission, Ombudsman. I tried a number of other government agencies, and as I said, that you just didn't have anybody that was able to assist. It wasn't so much the legal aspect, although the initial legal advice is of course critical. But my issue was that it wasn't that I was had challenges so much in reporting it and knowing to report it. It was actually about the ramifications that were coming thick and fast, and there was nobody who was able to step in. I asked the courts to, and again they found that they could only do that to a varying degree. So there really is no safety net.
I guess further to that, Ms. Blake, you mentioned the importance of independence, and I'm interested maybe for all of you, how important is that a Whistleblower Protection Authority is fully independent of other bodies and can actually
for me,
provide that support?
Yeah, I think it's paramount, because if you don't have somebody independent, then you're often at the judgment of ministers, other people that can influence the outcomes. And I think we've seen a level of, people being protected through that robo-debt system. Ministers have gone on and moved into great sanctioned jobs. Catherine Campbell was given an 800K job. I've had my wage significantly reduced, and I was at the lowest level of the employment, and these people have had no repercussions. And I believe if it was an independent body, then we'd have more protection.
And again, I'd just refer to my own case where the Crime and Corruption Commission believed that they had an obligation to look after me and to protect me, but it was found that they actually had, at best it was a competing obligation. The paramount duty was to investigate crime and corruption. And so there was nobody whose duty was to make sure that I was safe. And essentially you are left to your own resources. And of course, as individuals, you're personally attacked, and it means that you're very limited in the ways that you can, manage through that process. It's just highly traumatising.
And Ms. Kelsey, just in your case, you mentioned your submission, the need for whistleblower protections to extend to preparatory acts, which
Yes.
is what you were sort of targeted for, and what the government is currently prosecuting Richard Boyle for.
Absolutely. And so I think that the making of a public interest disclosure must be seen on a continuum, but the way that's interpreted is that it's at a distinct point in time, but that's very far from reality. Because for me, as I said, people were making, essentially telling me things from day one. And so it's all of that information that goes into, my mind in terms of at what point have I, formed a view that there's corrupt conduct that's occurring. I took legal advice before I made my public interest disclosure. And again, what's come out through other means is that it was clear that parties knew that I was actually undertaking some of those preparatory acts. And so what that means, of course, is that there's no protection, really for the whistleblower in terms of things that they need to do to ensure that they're in a position that they've, effectively formed a view that there is something that requires reporting. And I think the concern there is that it allows for a preemptive act by another party as soon as they become aware that in fact someone's taking steps, seeking legal advice to ensure they're in the right position to make a public interest disclosure.
Thank you very much. Thank you, Chair.
Thank you, Senator Pocock. Senator Pauline, just for the witnesses' benefit, we're working in about kind of 5-minute blocks to allow senators to ask some questions and get around to hear what you've got to say.
Thank you, Chair, and thank you to the witnesses for appearing before us. A really important issue. What I'd like to put to the panel is the standalone body at a Commonwealth level that this bill is proposing. I was wondering if you could outline to me the cost and the sort of resourcing that would be needed to have this put in place.
Are you asking me? I've got no idea.
Yeah, I think the questions are for the next panel. Senator?
Really? Well, I just wanted to get a sense of the proposal in the bill from the two witnesses, how they see this is really going to overcome the situation that they faced, and there will be a resourcing issue attached to this and a cost to it, and the experience also of that they've had in terms of any review that's been done in their own state.
I don't think you can put a cost on integrity. So having somewhere that's you're saying there's going to be resources allocated to that, I don't think you can put a price on public confidence and doing what's the best in the public interest. So
You can't put a price on what you've been through either, I'll tell you that much.
yeah, there's no price you can really put on that, but I certainly understand that it would come at a cost, but at the cost of not doing it is far more. Look at the billions of dollars that were wasted over the Robodebt debacle that could have been stopped had there been an independent authority that could have captured it before it began.
And I would say that I think that at a time when trust in government institutions is essentially at an all-time low, it's actually an investment. I think that it's important that we don't look at this in terms of an isolated issue. This is about all of the institutions that the government has and how we ensure that the Australian community can actually build a level of trust and confidence in what they do.
In terms of I was just wondering if I could then turn to Mr. Gentile. Can you actually just remind me of what year it was that you blew the whistle, and could you just expand on the sort of regime that commenced in 2019 under the Corporation Act?
Yes, so, pardon me. So it was 2004. So at the time, there wasn't, the type of focus there is now on integrity and ethics within institutions. And I'm not even actually sure whether there was a whistleblower hotline in the organisation I worked at. There has been a significant shift since those amendments to the Corporations Act that you allude to, where there's, requirements for most private organisations. So we're just going to keep that in mind, that it only applies to organisations in the private sector that have, arrangements in place for whistleblowers. The big question mark is, and there's no doubt there's been improvements, the big question mark is when those internal systems fail. Where do you go in that instance? And at the moment, if there was a whistleblower who worked at an organisation, or a prospective whistleblower who worked at an organisation where they'd lost faith in that organisation, they couldn't trust the internal whistleblower channel, I'm not actually sure who they could turn to.
You did say you had a more positive experience than the other two witnesses. Why do you think that was?
So like I said when I was giving my opening remarks, I think it was, more by accident than my design. There's a number of factors I could potentially point to. They include, firstly, anyone that was remotely involved with the wrongdoing was either dismissed or resigned. So I didn't have to walk into an organisation where I had to face into the people who are responsible for the wrongdoing. There were some really supportive colleagues around me who, kept seeing beyond that incident and kept seeing that, I had potential and deserved to be looked after. And although I was very, very junior at the time, and I wasn't privy to any discussions at a senior level, I dare say there were discussions at a senior level where, an effort was to be made to try and protect me. But like I said, I always make the point that I am just one piece of data, and that's why I encourage the committee to become very familiar with that Whistling While They Work research project, which explored in a far more detailed level and using a pretty significant data set of what are the factors that result in positive outcomes for whistleblowers.
Thank you,
Thanks,
Senator Polley. Senator Shoebridge.
Thanks, Chair, and thanks to all the witnesses. I know none of you are budget experts, but the Dutch Whistleblowing Authority has about a €4 million budget, which is about $7.2 million Australian. I don't think it'll break the bank. Could I ask you, Sharon, just in terms of the preliminary steps and the protection, was there some kind of whistleblowing state protection that covered you at Logan City Council?
Yes, there was the Public Interest Disclosure Act. But essentially, I should say thank you for the question, because sometimes people assume that because it's an offence in terms of taking retaliatory action against a whistleblower, that's sufficient to deter people. What I would say to that is that although there are protections in legislation, we know that the likelihood of somebody being actually prosecuted for taking retaliatory action is very far and few between. And we also know the bar is extremely high. And so even though there are some protections in the legislation, the reality is they're not used. They're not used because even though people may try and access them, the bar in terms of that is extremely high. And as I found in my case, even though there were criminal proceedings that occurred resulting from my public interest disclosure, that in fact it wasn't enough to, and this is my position, to deter people in terms of some of the actions that were taken. So yes, there was there was legislation. It was insufficient, even though most people would recognise that the Queensland Crime and Corruption Commission was essentially set up after the Fitzgerald inquiry as really leading edge. And really if that's some of the best that we have in the country, then that's a concern. It's also why it must be independent.
Yeah, and in terms of having someone, a clear statutory body who's responsible for enforcing those provisions, perhaps taking action, referring matters to the DPP where there's been a clear case of retaliation, an independent authority would be a good starting point for that, wouldn't it?
Yes, I would think so, even though the Crime and Corruption Commission did just that. But the prosecution of the parties that voted for my termination didn't actually succeed through the committal process. And I think that's, again, because that bar is extremely high. And, of course, access to evidence and all of those things are a challenge. So, yes, I think that really the legislation needs to be extremely clear and extremely strong in terms of who it requires to look after whistleblowers and in what capacity.
So there are really kind of two things that come from that. One is ensuring that the protections and the offences are very clear,
yes.
And it's not some sort of legal minefield.
Yes.
And secondly, having a single well-resourced authority that knows how to gather the evidence, knows how the law works, and therefore is able to effectively enforce the provisions. Those two things kind of go together, don't they?
Absolutely. And I think that the reality is for many of the people that were involved in my case, it was really the first time that they were trying to undertake either enforcement action or, in fact, I'll say action through the Queensland Industrial Relations Commission relative to whistleblowing. So there was nobody, if you like, that was a true expert and was dedicated in this area.
Yeah. Dennis, could I go to you? And again, thanks for giving a more positive experience. So often you hear from whistleblowers that you lose your job, you lose your family, you lose your house, and but I might do it again. That's often the experience of whistleblowers, and it's interesting to hear that Commonwealth Bank in your case was positive. But are you aware of the Commonwealth Bank's response to Jeff Morris when he blew the whistle?
Yes, I was at the National Australia Bank. Just to be clear, yeah, that's fine.
Yeah.
So I am aware of, the Jeff Morris, pardon me, and there are other whistleblowers within financial services industry whose stories are far less positive than mine. I know that I'm a bit of an outlier within this community. I often get reminded that by fellow whistleblowers that sometimes they'd like me to keep quiet because my story doesn't reflect reality. But I think, it's important that my experience is shared. Like I said, I think that, with hindsight, there are a lot of things that came together that made me lucky, to be totally frank. I think it was, in some cases, more by accident than by design that my story ended up the way that it did.
And in terms of structural change in the NAB, the benefit of blowing the whistle, what do you think structural benefits that happened?
Sorry, just to interrupt for a second, Senator Shoebridge, that's your final question before I need to share the call.
Sure.
Yeah, it was significant. So look, what I heard years after the fact, so just before I left the organisation, is that some of the senior people felt that matter and that incident caused the internal reform, which held the organisation in a far better position in the years that followed. So it's always a case with instances like this that it's very painful to go through for any institution. But if you're prepared to face into it and look into it and undertake the necessary reform, you will be a better place for it.
No one wants to get the jab, but it can help you in the future.
That's right.
Thank you, Senator Shoebridge. Senator Lambie.
Thank you very much. Sorry, I know that we're getting behind here. So, Miss Blake, are you under Comcare at the moment?
Yes, I am.
Yeah. How's that going for you?
Dreadfully.
Is it? I still haven't got any better, even though they've got an independent investigation on them.
Yes.
Did you know there's an
espoused.
independent... have you spoken to those people doing that?
No, I haven't.
Well, I'd like you to. So that's the first thing. Before you go, I'd like to give you their name and number to contact them.
Thank you.
And Comcare has reduced you down to 75% of your wage.
Yep.
That's not the wage you would have got overtime in that.
No.
You can say no. Is there... Could you tell me what you were getting paid to what you don't have to, and I understand if it's a private matter.
I'm quite open. I'm living on around about $60,000 a year now. Mm-hmm. I'm a single mother of 3 children trying to pay a mortgage. I know you've got your own family, you know exactly what that's like. I think Comcare is problematic. I do have some legal support in that area trying to address some of that.
Okay. And are they helping you? Are they paying your medical costs? Do you have medical costs?
Some. They rejected my claim to do a in-stay for PTSD and alcohol dependency, saying that there wasn't enough evidence.
Oh, they don't want you to get better. How unusual of Comcare.
But Services Australia graciously said they would fund it independently.
That's great.
Yeah, but there's still some issues with that also. So,
do you think you'll get back into the workforce? Is there an option for you to come back into the public service?
There is. I don't think I'll ever go back to the public service. I'm not sure that I have enough to continue to go back into that line of work.
That's okay, but you would like to get back to working in your working life when you get it
I'd like
sorted
to.
out.
Yeah.
Okay.
I felt like I was really pushed out. Again, there is all of the protections, but I found in the public service, certainly Services Australia, it was more espoused values rather than values in practice. And in practice, I experienced ostracising, extra critical monitoring of my work, listening to my phone calls. So I certainly felt the scrutiny and higher pressure after I'd been at the Royal Commission. So then in the end, I felt like I wasn't getting anywhere, only more pressure and pressure, and I just left on stress leave, really.
Right. So effectively they were bastardising you.
That's what it felt like,
Excuse my
certainly.
French, but that's what it is.
That's certainly
Okay.
what it felt like. Thank you.
Thank you. Thank you very much, both of you, coming forward. I won't keep it because we're already running late, but it takes a lot of courage to keep going and telling your stories. So good on you for doing that. I applaud you from the bottom of my heart because I know how difficult it is. Good on you, both
Thank
of you.
you. Let's hope it makes a difference.
Concur with those comments by Senator Lambie. I want to sincerely thank all of you for coming forward and sharing your experience today and taking the time to give evidence. If you've been asked to provide any additional information, which I don't think you have, I think there's been an offer of information being provided to you. But if there's anything else you'd like to provide, please forward it to the Secretary by the 21st of August. You'll be sent a copy of the transcript of your evidence and you'll have an opportunity to request corrections to any transcription errors. Thank you so much. We'll take a short break while we welcome our next witnesses.
Thank you.
Thank you.
I now welcome representatives from Transparency International Australia, Griffith University and Human Rights Law Centre. I want to thank each of you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. Also, for the Hansard record, would you please state your full name and the capacity in which you appear, and I'll start from the left.
Kieran Pender, Human Rights Law Centre.
Madeline Howe, Human Rights Law Centre.
Thank you. Mr Moore. Sorry, you're on mute, Mr Moore.
Clancy Moore, Transparency International Australia.
Thank you. Dr Brown.
Yeah, Professor AJ Brown. I'm a Professor of Public Policy and Law at Griffith University and the Chair of Transparency International Australia.
Okay, do we have Miss Olsen?
Yes, so Jane Olsen, currently at Griffith University.
Great. Thank you very much. Would any of you like to make a brief opening statement before we proceed to questions?
Yes, thank you, Chair. I'll make a brief opening statement on behalf of Transparency International Australia.
No worries, Mr Moore.
Committee members, as we all know, whistleblowers make Australia a better place. They save lives, like nurse Tony Hoffman, who blew the whistle on Dr. Death at Bundaberg Hospital. They shine a light on corruption and bring about justice, like James Shelton and Brian Hood, who blew the whistle on RBA company Security and Note Printing Australia in Australia's largest ever foreign bribery conviction. And more often than not, they act as early warning systems for companies and organisations before issues and harm take hold. Yet, many whistleblowers are punished and not protected. 2018 research by my colleagues at Griffith University, which surveyed 17,000 employees, including 5,500 whistleblowers, shows that 56% of whistleblowers suffer serious repercussions for speaking out, and 3 in 10 face harassment, intimidation and job loss. This injustice has a chilling effect, meaning that many people choose to remain silent. Our submissions and our final principles for a Whistleblower Protection Authority were developed with many whistleblowers, including Sharon Kelsey and Dennis Gentleman, who appeared earlier on today. They are also developed with the Human Rights Law Centre and Griffith University. So, we strongly support the introduction of an independent and well-resourced Whistleblower Protection Authority. A Whistleblower Protection Authority, as per the bill, would help implement all federal whistleblowing laws by being a source of practical guidance and support for prospective, current and former whistleblowers, but also assisting agencies, companies and regulatory bodies with the coordination and management of disclosures. The Whistleblower Protection Authority would also promote best practice whistleblowing across the Commonwealth and investigate alleged detrimental actions and support enforcement litigation where necessary. And importantly, committee members, and I really want to stress this point, it would also and should also administer a reward scheme for whistleblowers. Senators, support for whistleblower protection across the Parliament is strong. It is not an issue of left or right or politics. It is simply an issue of fairness, of giving people a fair go for speaking out. Thank you for your time, and I now pass it over to my colleagues, Mr. Pender and Ms. Howe from the Human Rights Law Centre before Professor AJ Brown will talk more.
Thank you. We thank the committee for the opportunity to appear today. The Human Rights Law Centre launched the Whistleblower Project in mid-2023. Our service was designed to fill a gap in the legal services landscape where too many whistleblowers have fallen through the cracks without support. Since launching, we have had almost 450 inquiries for assistance. We have no doubt that that gap is there. I work as a lawyer within the team and triage each inquiry to our service. Every day I see firsthand the legal, financial and emotional toll of whistleblowing. For many who come to us, we are the last frontier for seeking support. For every whistleblower we assist, there are at least 2 others that we do not have the capacity to help. Our data shows that almost 4 in 5 whistleblowers will suffer reprisal after having blown the whistle without any guidance or assistance. 1 in 4 whistleblowers will suffer bullying or harassment. 1 in 5 will have workplace performance allegations made against them. With alarming frequency, we are seeing whistleblowers hit with retaliatory legal action, few of whom can afford to defend such claims from their employers. For those that don't suffer workplace reprisal, procedural burnout from drawn-out investigations can be just as detrimental in the long term. The law may be providing of protections, but the reality is that more often than not, whistleblowers pay a very high price when it comes to holding business and government to account. In our work, we have found that ongoing legal assistance and procedural support from the outset can considerably improve the experience of whistleblowers through the disclosure process, particularly when engaging with regulatory agencies, and also limit the risk and impact of reprisal. But we are a small philanthropically funded organisation with only a handful of lawyers. We cannot help everyone. To expect a complex legal framework to function effectively without the appropriate infrastructure is a grave oversight, the burden of which is being shouldered by the whistleblowers that we are speaking to every single day. In our view, a Whistleblower Protection Authority is a long overdue step to reduce the downstream costs on the public, the economy, and ultimately the whistleblower of an incomplete framework. We urge the committee to recommend that the government establish a Whistleblower Protection Authority consistent with this bill, together with comprehensive best practice law reform to harmonise and strengthen federal whistleblowing laws. We look forward to your questions, and we will seek to answer them informed by the practical perspective of our client work. Thank you.
Thank you. Mr. Brown?
Yes, thanks, Madam Chair. I'll be very brief because I do have a hard stop at 9:45, but my colleague Jane Olsen will remain with you. I think from a Griffith University perspective, it's gratifying to hear people refer to some of the research that Griffith University has led over many years, the Whistling While They Work 1 and 2 projects, which has been done collaboratively with most of the relevant public integrity agencies, and including agencies who are responsible for managing whistleblowing all around the country and supported by the Australian Research Council. So we do have, compared to 20 years ago, we do have a considerable body of evidence that really does now make it clear just how vital it is to have an independent agency which will actually enforce protections and make them real, which is the issue over which there's been a lot of debate previously, but the jury really is in on the fact that is the single biggest gap, the single greatest difficulty in actually making whistleblower protections, and therefore most of the rest of the integrity system actually work effectively. The main thing that three things I guess I really want to emphasise. One is that the Commonwealth really is in a unique position because it is in a position to legislate to create a Whistleblower Protection Authority that will enforce protections under federal laws, not just for the public sector, but for the private sector and the not-for-profit sector in a very comprehensive way. There's both a need to do that for the protections to work effectively, but also a huge opportunity to do that. And that's a feature which is largely addressed by this bill, and it would be excellent to see the committee follow other committees like the Parliamentary Joint Committee on Corporations and Financial Services in really helping the Parliament and helping the government with the basic policy objectives and parameters of what a good Whistleblower Protection Authority would look like. So that's the first thing that we're really talking about something which would be a game changer if its scope is got right. The second is just to emphasise that I think irrespective of what the committee decides, ends up thinking it decides about this particular bill, the committee is in an enormously important position, as indicated by our recommendations, to lay the groundwork for what a final bill might look like, knowing that governments obviously always prefer to have their own bill rather than a private member's bill. But it's really not a question of this bill or nothing. It's really a question of, okay, if not this bill, then what is the government's proposal going to look like that will actually do the job even better than this bill would, if in fact the committee decides that this bill is not the one. And then finally, and really this is just to say that when I have to leave, I know my colleague Jane Olsen can stay. A lot of our research in terms of the practical institutional implications of getting this right have been led by Jane. Jane speaks with authority not only as a researcher but having run the public interest disclosure management function for the New South Wales Ombudsman, so it's the biggest government in the country and the biggest whistleblowing scheme in the country. And she's the one who's responsible for the gap analysis that really lays out very clearly that the types of functions that are needed for that a Whistleblower Protection Authority would fill are simply not covered in the current institutional landscape and can only be covered if there is really a very fundamental shift in the way that that landscape works, which is really why a Whistleblower Protection Authority is now the key issue. So thanks very much for the opportunity, Chair, and sorry that I do have to leave shortly.
That's okay. Thank you for making time for the committee this morning. We'll proceed to questions now, unless somebody else has got something they want to say before we do. Otherwise, I'll go to Senator Pocock.
Thank you all for your time and all your work in this area for many years. I'll start with the Human Rights Law Centre. We heard in the last panel, Senator Polly was asking questions about the cost of a Whistleblower Protection Authority, and I'm aware that the member for Indi, Helen Haynes, has actually had the authority costed. I'm interested if you're aware of this and if you can talk the committee, I guess, through what it would cost and also what would be saving. We heard a lot about robo-debt. What I'm saying is that was $2 billion. We saw the Royal Commission, tens of millions of dollars. So if you could just maybe talk about the cost.
Thanks, Senator Pocock, and I also thank Senator Polly for asking that important question. As Senator Pocock mentioned, the member for Indi, Dr Helen Haynes, MP, who was a co-sponsor of this bill in the House of Representatives, had the Parliamentary Budget Office costs this bill in the lead up to the election, and the cost over the forward estimates was about $100 million. That was for an agency of 80 full-time equivalent. It's about $20 million annually, plus some startup costs. Of course, this bill is just one option of different ways that this body could be established, and we've gone into more detail on that in our submission. I don't think that is a high price to pay for ensuring our whistleblowing regimes work. And if anything, I think that is a very small investment that will reap significant savings. Senator Pocock mentioned the cost of robo-debt. $1.8 billion paid out in a class action, $33 million to run a Royal Commission, not to mention the lives lost and the impact on integrity and public confidence in our systems. If a Whistleblower Protection Authority avoids the next robo-debt, then it's paid for itself for hundreds of years into the future. But more to the point, there are huge downstream savings. A body like this will make our regulatory agencies more effective. It will make the National Anti-Corruption Commission more effective. It will make the Commonwealth Ombudsman more effective. It will make ASIC more effective. Those agencies will have more success pursuing enforcement actions, recovering penalties, fines, compensation when things go wrong. Such an agency will also help avoid cases that go wrong, bogging up our court system, costing public resourcing in that context. Hopefully an agency like this could avoid a recurrence of recent prosecutions of whistleblowers, which have cost the Commonwealth almost $10 million in prosecuting, and the costs of ensuring secrecy shroud some of those prosecutions. There's also a behavioural benefit when you have a Whistleblower Protection Authority. Companies and public officials and agencies will act differently because they know that people can get help in speaking up. I just wanted to briefly mention the US example, which has really led the way here and has an equivalent body in the public sector and equivalent offices in a number of private sector regulatory authorities. One of the things that Mr Moore mentioned was such a body overseeing a whistleblower reward scheme. In the United States, those schemes have recovered over $100 billion for the US taxpayer. Whistleblowers have walked away, just in relation to one scheme, more than $100 billion recovered. Whistleblowers have walked away with over 13 billion Australian dollars. So that's a ratio of 1 to 10 saved. Other studies have put the benefit to cost ratio at more than 20 to 1. Whistleblowing programs don't cost much money and in the long term will reap huge benefits both financially and non-financial benefits.
Thank you. I've got a question for Transparency International. Mr. Moore, from international experience, what benefits come from having a dedicated whistleblower protection authority?
Yeah, thank you, Senator. As Mr. Pender outlined, in the US, it actually is revenue positive in many instances as well. The other international examples from the Netherlands, Slovakia, what am I trying to say? Ireland and Slovakia, have really helped change the culture around whistleblowers, and I think a potential reward scheme would actually shift the cultural norms around people that speak out from being a troublemaker, as some see them, to actually being heroes like they should be, and they are. So I think there's an economic benefit, there's a cultural change benefit as well, but it also helps build trust in government and institutions and the private sector as well, so benefits across different areas, Senator.
Thank you. And then just a question for Professor Brown. How could the Whistleblower Protection Authority work with and avoid duplicating work done by existing bodies like the Commonwealth Ombudsman or the NAC? How would you see that working?
Well, I think as Kieran Pender just said, the Whistleblower Protection Authority would effectively work as a support to all of the regulatory agencies and investigative agencies, because it would it wouldn't. I mean, people say one-stop shop, but I think, as is reflected in some of our submissions, really the approach is no wrong doors. It really means that when those agencies receive disclosures where there are protection obligations that need to go with managing the people who make those disclosures, then basically this agency can take on the burden of helping ensure those protection obligations are met and helping manage and support the whistleblowers in a way that makes it cheaper and easier for the other agencies. So there's a lot of cooperation and collaboration required, and I think that's why we don't see this as being, we see it as being independent in terms of its protection obligations and capacity to act, but very much part of the system when it comes to working closely with all the investigative and regulatory agencies. But basically it would alleviate a lot of the responsibility. I mean, currently, rather than having every agency having to provide in-depth witness support functions, compensation functions, protection functions for their whistleblowers, you would have one agency that would do that for all the other agencies. The other way it would support it is that whenever potential whistleblowers are confused or uncertain about where to go, they may well go to an existing agency that they see as most relevant. But if in doubt, there would always be the Whistleblower Protection Authority that someone could tell them to go to, who has the benefit then of being able to give them sort of confidential advice on how the process would work before they commence the process, which is often the key step to in a whistleblower's mind about approaching an agency that full of people that they don't know. It's the first step in just getting information to say, okay, before I take the next step, I know what's going to happen. And a Whistleblower Protection Authority would be especially placed to be able to do that, as well as navigate across multiple regimes and ensure that people do end up in the right place and help, if necessary, help hold their hand to take them to the right place, which is often where things go wrong at the moment, and which normally integrity and the existing integrity agencies just simply don't have the capacity to do, even if they have the inclination, and up until now, often they haven't had the inclination either. I guess at the other end, I mean, apart from then being in a position to see through on the enforcement of protections, like follow through to see that protections are enforced down the track after the primary case has moved on, which gives the Whistleblower Protection Authority quite a different role to any of the existing roles of most of the, or any of the integrity and enforcement agencies. The final one is really how it interfaces with either Commonwealth agencies or companies in terms of oversight and supporting and monitoring the effectiveness of internal whistleblowing regimes within organisations, line organisations, agencies or companies. That's where the existing agencies like the Ombudsman or ASIC have some statutory responsibilities currently. And so really it's just a matter of the final design to say, okay, who should have the job of making sure that entities, whether they're companies or whether they're public sector agencies, have good whistleblower protection systems. That could be handled by the Whistleblower Protection Authority. It could be handled by the existing agencies and supported by the Whistleblower Protection Authority. Again, it's just a matter of good institutional and legislative design to sort of finalise who's responsible for what. Because as I said originally, it's not a matter of this agency taking over everything that other agencies should remain responsible for, but basically providing the grunt work, being able to basically carry the lion's share of the responsibility to make sure that the things that aren't getting done at the moment do get done and do get done effectively.
Thank you, Professor Brown. Thank you.
Thank you, Senator Pocock. Senator Polly.
Thank you very much. I just want to follow on from the question Senator Pocock addressed in relation to the cost. I was just wondering if you can break down that cost of the establishment of the proposed advisory council.
Senator Polly, I was only going off what's been publicly released by the Parliamentary Budget Office, which doesn't have that level of detail, but the cost was for 80 full-time equivalent in the agency, about 30 million in the establishment year, and then about 20 million per annum thereafter in staffing costs.
Yes.
Just to speak to the Advisory Council generally, and in our design principles for a Whistleblower Protection Authority, we also speak in more detail to this. We think it's really important that a body like this draws in perspective of whistleblowers, of companies in relation to how internal whistleblowing schemes operate, of former public officials, of regulatory agencies. And so we think an Advisory Council is a really important mechanism to ensure that this agency is acting in an effective way.
Yeah, and I understand that. I'm just trying to get to a figure of the difference in the two bodies, in the costs involved in that and the staffing levels, and also the cost of ICT to set up such an agency. So you can't provide any of those figures. Do you have the modelling that this bill was based on? And I assume you've had some input into drafting of this bill.
We've provided assistance to a number of crossbench MPs and senators in developing this bill, which is aligned with the draft and then ultimately final design principles that have been published by our joint organisations. I think the evolution of this bill, if you look at the crossbench bill for a National Anti-Corruption Authority, 2017, 2018, 2019 and so on, from people like firstly Cathy McGowan, then Helen Haynes, the Greens. I see former Senator Rex Patrick on the screen for the subsequent session. I know he was involved in that as well. That had a Whistleblower Protection Commissioner built into it, which ultimately didn't become part of the National Anti-Corruption Commission as established. And so my understanding is that formed the basis of this, which was then further developed to reflect the draft design principles.
Would you be able to take on notice and come back to the committee in relation to those costs, just that we've got limited time? And I was wondering too, under this bill, how would sensitive Australian national security information be protected?
So national security information is already provided for, and protection for that information in terms of whistleblowing pathways is already provided for under the Public Interest Disclosure Act, the Federal Public Sector Whistleblowing Law. I guess the efficacy of this bill is in part because it builds on all of those existing regimes. So there's currently 9 different federal whistleblowing laws. This bill sits on top and interacts with them. Now, in an ideal world, we would get the establishment of a federal whistleblower protection Protection Authority alongside reform to those laws, harmonisation, consistency. But the simplicity of this bill at the moment is it sits on top of and picks up those laws, and so the current way that the Public Interest Disclosure Act deals with national security information and protects that information is dealt with. I think that's Senator, your question is a good one, that perhaps further consideration will be needed into how, for example, the Inspector General of Intelligence and Security, which is the national security oversight body, intersects with this agency, which I think also points to the need for some more holistic whole-of-government thinking on these issues. But the beauty and the simplicity of this bill is it sits on top of the existing framework but provides support, oversight, enforcement.
So if I go to the Human Rights Law Centre, I just want to clarify whether the centre offers legal advice to whistleblowers.
That's correct, Senator. We offer advice to whistleblowers across all whistleblowing laws, federal, state and territory.
And do you consider that independent legal advice is a key feature of the rule of law?
Yes, Senator.
So the Commonwealth Ombudsman's submission raises a concern about the authority as an oversight body also being charged with delivering legal advice. The submission indicates that these functions should be kept separate to manage perceived or actual conflicts of interest. As an organisation that provides legal advice, from your knowledge, the concerns raised by the Ombudsman?
Senator,
do you acknowledge the concerns that have been raised by the Ombudsman?
I think my understanding of what's proposed by this bill, if you look at the bill and you look at the explanatory memorandum, is that the authority can oversee and facilitate schemes, i.e. pay for whistleblowers to get access to independent legal advice. I don't understand the bill proposing that the body itself is giving legal advice. That would certainly raise concerns. However, it's very typical for Commonwealth agencies and regulators to oversee schemes and pay for people to get legal advice. The Fair Work Ombudsman runs a scheme where people can get legal advice through law firms. ASIC, I know, from time to time pays for witnesses in proceedings to get access to independent legal advice. I think that the critical thing is at the moment there is no access to legal support for whistleblowers other than whistleblowers paying out of their own pocket or coming to us. Our work is entirely philanthropically funded. We can't help everyone. So what's really game-changing about this bill is it would establish a Commonwealth agency that could oversee a scheme to facilitate whistleblowers getting legal advice. And that's not. That's also something that's been proposed in Victoria, in Queensland. I think later today the committee will hear from the New South Wales Ombudsman, which is expanding the services and support it offers whistleblowers. So this is, I think, all consistent with the tide that we're seeing at a state level and at an international level.
Thank you.
So how is...
Sorry, Senator Polly, I'm going to need to share the call and I'll go to Senator Shoebridge.
Thanks, Chair. One of the problems that agencies have dealing with whistleblowing at the moment is often when an agency gets a whistleblowing concern raised, a declaration provided, the people they go to are often the manager, the supervisor, the team where that whistleblower works. And they often obviously have a distinct interest in the matter, and that can, very often set up a response where it becomes an issue of personnel manager for the whistleblower, complaints are generated, there's a kind of self-serving, self-sealing element to the way in which agencies deal with that. And even in the best of worlds, without some kind of independence, agencies tend to back themselves in and tend to ostracise the whistleblower. Could I just ask any of you if that is a kind of pattern that we see, and whether or not an independent whistleblowing authority that kind of does has one remove and can do some initial investigations, how that actually might benefit an agency?
I mean, I could probably answer that, Senator, as my final contribution before I shoot through. And one is that, that is definitely the default dynamic. That's a natural dynamic in institutions and organisations. That's really why whistleblower protections need to exist and why they have to have the right mechanisms. But there's two things we know now from the way that integrity institutions work generally. One is that those dynamics that you describe change as soon as people in an organisation know that somebody from outside the organisation with authority is watching or looking at them. That changes immediately in most cases, and usually for the better. And so a whistleblower protection authority would have that function in a way that existing agencies don't provide. And then the second thing, your second point about independent investigations is the critical one, and that is probably the single biggest gap in the way that the systems currently work, which is the lack of ready recourse to an independent investigation of how whistleblower treatment has actually occurred and whether there's been any detriment or mismanagement of a whistleblower, let alone direct reprisals or repercussions, because that can only be done in many, many cases, that can only be done independently. And that's really the gap, because currently none of the legislative regimes really set up an independent authority to be able to do those sorts of investigations as a matter of course in the way that most people would actually assume, is the case or should be the case.
And once those dynamics start in an agency, it becomes sort of self-serving. The agency then has to defend its HR actions against the whistleblower, and they double down. And so when it starts on the wrong foot like that, it can take years and to unwind and actually get to the heart of the problem.
Yeah, and unless it's corrected early, and we do know from experience in the public sector and the private sector that if there is a trigger to change that dynamic early in the piece, it can change the entire story for the reason that you just said. So there is experience of integrity agencies and regulatory agencies breaking that dynamic quite early if they're in a position to do so. And one of the features of the regime reflected in our design principles and in the bill, and is based on the US public sector experience, is that very often, once with some independent intervention, an agency realises that dynamic might not produce the best outcome for anybody, including the agency, then having a process, having a system to enable mediation, conciliation of not necessarily the wrongdoing that was originally disclosed, but of the treatment of the whistleblower, can be the fastest, cheapest way for the agency to get it, to basically to avoid going down the rabbit hole of retribution that ends up being so expensive for the agency or the company, and ultimately also in reputation terms often, as well as obviously damaging for the whistleblower, which is what the real focus is here. So there is, and that again is is part of what our current systems don't provide, and needs to be provided by somebody independent in order to be effective for the reasons that you've said.
Yeah, thanks for pressing that. I might throw that to the other panel, but also add this further point. One of the benefits of having an independent whistleblowing agency is it can kind of winnow out the whistleblowing complaints as well. So if a complaint has gone to a whistleblowing agency, to an independent whistleblowing authority, and they've identified that at least has, prima facie merit, when it then finds its way into the agency, they can treat it with more seriousness. And it may also be a way of ensuring the agency isn't dealing with a bunch of other complaints that were not validated by an independent authority. It also has a kind of sieve winnowing effect as well. But I might ask either of the other panel.
Yeah, thank you, Senator. I might just respond to your question, and then I'll hand it over to Ms Olsen and my colleagues at the Human Rights Law Centre. But yeah, you are right, Senator. The Whistleblower Protection Authority has a strong prevention focus and really aims to prevent harm from taking place. It can do that by a few functions. Firstly, it can provide assistance to federal agencies and organisations on best practice, how to handle disclosures, but also how to comply with federal laws as well. So it should be preventing harm from taking place in the first instance by intervening early, and as an independent, well-resourced body, it should be able to do that. Thank you.
does the Human Rights Law Centre, your experience of that kind of dynamic that whistleblowers find themselves in, is that true to the experience of at least of some whistleblowers?
Yes, I think, Senator, it goes to the procedural sort of burnout that we see whistleblowers experiencing. And then on the other side of that, as you've mentioned, you also have regulatory agencies who are using a lot of resources kind of triaging whistleblower reports, and it's natural that some of those are going to be missed, or that whistleblowers are not going to be receiving the appropriate support. A key function of the Whistleblower Protection Authority is the clearinghouse function.
Cool. I have some costs about the potential catering costs of a future authority, but I'll put them on notice.
Thank you, Senator Shoebridge, for providing the humour for today. I'll move to Senator Lambie.
Thank you very much. I just have a couple of questions here. First of all, and you can all answer this. I think there's only the couple of you, Mr. Patrick and Mr. Moore. I think it was you, Mr. Patrick. You stated that legally protected whistleblowers often.
Senator, Mr. Patrick's on the next panel.
Oh, he's on the next panel.
Sorry.
You'd be able to answer this anyway. Who have I got left? Sorry, ladies. Someone stated that legally protected whistleblowers often face retaliation with few remedies in practice. Can you explain the most significant legal and procedural gaps you see in the current framework on how this bill could actually close them and close that and support the whistleblower?
Yes, I'm happy to talk to this. Some of the research we've done at Griffith University looks at, I guess, the key functions that are needed in any strong whistleblower protection system, and this builds on some work done by our European colleagues. And what we found is that currently in the public sector, only 4 of those areas have clear responsibilities currently, and in the private and not-for sectors, there's only 2. And while we do have, I guess, quite strong arrangements in terms of ensuring that substantive wrongdoing is investigated, the biggest gaps in the current system are around the support and protection of whistleblowers themselves. So as Clancy just mentioned, there are 2 major areas. The first is in terms of preventing harm from occurring in the first place. So a Whistleblower Protection Authority would be able to support whistleblowers through what can be a really difficult process, either legally, psychologically, or in other practical ways, as well as having that early intervention with agencies and organisations to deal with matters properly so that they don't spiral out of control, as we've just discussed. And the second major gap is what happens when, unfortunately, harm does occur. And currently there's no easily accessible ways for whistleblowers to have those allegations of detriment against them looked into, if preferably resolved informally through an easy conciliation and mediation process, for example, or failing that, a proper independent investigation into what has happened, and then clear enforcement so that whistleblowers do receive some redress or some form of justice when they suffer simply for speaking up about matters that are in the public interest. And when we looked at the Whistleblower Protection Authority bill against the existing arrangements, there is a marked and comprehensive improvement. So under the proposed model, there are no gaps for either the public or the private sector. And it really does build in the powers and the duties that we need to actually deliver the functions that are missing right now.
Can I just add to that? In 2023, the Human Rights Law Centre published a report, The Cost of Courage, where we reviewed every whistleblowing case to go to judgment in Australia ever across all federal, state and territory laws across about 3 decades. There's been about 80 whistleblowing cases go to judgment. Only 1 whistleblower under federal law has ever received court-ordered compensation. That whistleblower received $5,000. One of the reasons for that is there's a huge barrier under our laws. All of the federal whistleblowing laws, your ability to commence proceedings is typically in the federal court. You need money, you need lawyers, and that's a very difficult and time-consuming process. And so I think what's really important about the authority is it will have this mediation and conciliation function that Ms Olsen mentioned. It can provide legal support, it can provide enforcement, Not dissimilarly to the way the Fair Work Ombudsman undertakes strategic enforcement. ASIC has just recently brought the first ever strategic enforcement action under its whistleblowing powers, but to have a dedicated body doing that, doing it across all federal whistleblowing laws, would be really important in ensuring access to justice.
Okay, thank you. And I'm just going back from, which you guys are probably, the 2017, we did the Whistleblower Protections Report. Anyway, you'll be glad to know that 8 years later, we have 11 of the 35 recommendations that are either in or partially. What a waste of time that is, just another inquiry. And secondly, why don't you tell me what the reward scheme is for people coming forward?
Sure.
Is there one?
I can start with that, and then others might want to add to it. I think you make a really important point, Senator, that what's proposed in this bill, what's proposed in our design principles, is not a novel idea. 31 years ago, in 1994, there was a Senate inquiry into federal whistleblowing laws. There were no federal whistleblowing laws at the time. The Senate inquiry said, we need whistleblowing laws and we need an agency to oversee them. Wow. It proposed we call that the Public Interest Disclosure Agency. I personally think Whistleblower Protection Authority has a better ring to it. But this was an idea that was floated 31 years ago. The 2017 inquiry, as recently as last year, the Parliamentary Joint Committee on Corporations and Financial Services recommended better whistleblower support. The Labor Party took the idea of a Whistleblower Protection Authority to the 2019 election. This is a good idea that's time has come. And this is also a body that can facilitate a reward scheme. There's currently no whistleblower reward schemes in Australia. They've been very successful in the United States. The United Kingdom is currently proceeding to introduce them. We've got equivalent schemes in South Korea, in Nigeria, in a few other jurisdictions. It's a really good way of supporting whistleblowers and particularly supporting regulators to increase the quality and quantity of information that comes to them. And a body like this would be best placed to administer such a scheme.
Okay, and I think that was about it. So there is nothing at this point in time encouraging whistleblowers to come forward. First of all, they're not protected, let's be honest. And in your own words, how do you think the NAC's actually going? Do you want to comment on that at all? I mean, we do have a National Anti-Corruption Commission where we have whistleblowers going to them. Do you know whether or not those whistleblowers, I know it's fairly early in its infancy, whether those whistleblowers are getting the protection that they actually need, or are they wasting their time coming forward to the NAC?
I think one of the things missing from the establishment of the National Anti-Corruption Commission was the Whistleblower Protection Authority that was initially proposed in the crossbench bill to establish the NAC, and ultimately what seeks to be addressed by this bill. As no doubt you'll hear from the Commission later today, they deal with whistleblowers often and they provide some support to those whistleblowers, but it is not their dedicated function to do so. Myself and my colleague, Ms Howell, we are often providing legal advice and support to people who are blowing the whistle to the National Anti-Corruption Commission, who are participating in National Anti-Corruption Commission investigations over a very long time. I hope that we make their experience better as a result. I hope the NAC benefits from our assistance to those whistleblowers. That work is all funded by philanthropic donations to support our work and the pro bono support we receive from lawyers and barristers. Why is that the case? Why is there not dedicated funding to help people who bring information to the NAC to enable it to do its job? The Commission can't do its job without information brought to it from insiders. A Whistleblower Protection Authority is the missing piece of the puzzle.
Well, I'll just have one more question. Do you think a lot more whistleblowers would come forward if they actually had the protection that they needed? And do you think that that both the major parties here are delusional to this? Because quite frankly, you said 94, 2017, last year it was recommended, and once again we're still not doing anything to protect our whistleblowers. So why would they bother to come forward? Do you think governments just don't want to deal with them when they do come forward?
I think more whistleblowers will come forward if there's better support and protection. And I think what is noteworthy about this area is that it is so multi-partisan. I'm sure later on we might hear from the Australia Institute and the Whistleblower Justice Fund about polling that's been done in this area. There is incredible multi-partisan support for stronger whistleblower protections, and that's what gives me optimism that ultimately this is reform that will get done.
Thank you. I have no further questions. Thank you, Chair.
Thank you very much. And I want to thank each of our witnesses for coming forward and providing evidence to the committee today. If you've been asked to provide any additional information, which you have today, then we would ask that you please provide that to the Secretary by Thursday the 21st of August. Each of you will be sent a copy of your transcript and we'll have an opportunity to request any corrections to transcription errors. Thank you very much. We'll take a short break while we welcome our next witnesses. Representatives from the Community and Public Sector Union, the Australia Institute, Alliance for Journalist Freedom and Whistleblower Justice Fund. Thank you for taking time to appear before the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat today as well. I note that one of our witnesses is appearing from overseas and you should be aware that this protection only applies in Australia. For the Hansard record, would you please state your full name and the capacity in which you appear, and I'll start with the people in the room.
Bill Brown, Director of the Australia Institute's Democracy and Accountability Program.
Sky Predovec and Cantor Fellow at the Australia Institute.
Thank you. We'll proceed to online. And we'll...
Mr. Rex Patrick from the Whistleblower Justice Fund.
Thank you, Mr. Patrick.
Professor Peter Grester from the Alliance for Journalist Freedom and Macquarie University.
Thank you, Professor Grest.
Rebecca Fawcett from the CPSU. I'm the CPSU's Deputy Secretary.
Excellent. Thank you very much. Would any of you like to make a brief opening statement before we proceed to questions?
Yeah.
Thank you.
Thank you for having us here today. As you've already heard from other people giving evidence, whistleblower protections at this point are not adequate in Australia. The Public Interest Disclosure Act has failed to prevent the prosecution of whistleblowers who expose serious alleged misconduct, and recommendations from the 2016 Moss Review to improve the laws have only been partially implemented. A whistleblower protection authority like the one proposed by this bill would significantly improve Australia's whistleblowing laws and fill a crucial gap in the functions of the National Anti-Corruption Commission. And parliamentary committees have recommended the establishment of such an authority several times, first in 1994 and most recently in 2017. And equivalent bodies exist in the Netherlands, the United States, Slovakia and the Maldives and elsewhere. And I think the major unique contribution we can bring to this inquiry is our polling research. So we've found broad support for stronger whistleblower protections, the establishment of a whistleblower protection authority, and the establishment of a whistleblower reward scheme, like was just discussed across Australian society. So in particular for the Whistleblower Protection Authority, research we conducted in February in collaboration with the Human Rights Legal Centre and the Whistleblower Justice Fund showed that 84% of Australians support the introduction of a Whistleblower Protection Authority and only 5% oppose. So that high level of support is reflected across states, across genders and across all voting intentions. Thank you.
Thank you. Is anyone else who'd like to make an opening statement before we proceed to questions?
Thank you, Seth.
I'm happy to...
Sorry, I think Ms. Fawcett.
Thank you, Senator. Before we start, I'd like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land that I am on today. I pay my respect to elders past and present, and I extend that respect to any First Nations people here with us. I appear today on behalf of the Community and Public Sector Union, the primary union representing the workers in the Australian Public Service. Our members are committed to delivering for government, the Parliament and the Australian community, and they take great care and pride in doing so. We welcome the opportunity to contribute to this inquiry and support the intent of the Whistleblower Protection Authority Bill. Whistleblowers are vital to the integrity of our public institutions. They expose misconduct, corruption, and systemic failures that would otherwise remain hidden. Yet, as recent cases have shown, our current protections are inadequate. Whistleblowers continue to face serious personal and professional consequences for doing the right thing. The CPSU therefore supports the establishment of the Whistleblower Protection Authority to protect whistleblowers and support them to make disclosures. As a union, we have seen situations where public servants are aware of wrongdoing, but their attempts to raise concerns have been hobbled by existing structures and a lack of protections. This most notably occurred during robo-debt, with devastating impacts for some of the most vulnerable members of the Australian community. In our submission to the Royal Commission into the robo-debt scheme, the union highlighted how Services Australia at the time weaponised the APS Code of Conduct to silence legitimate concerns from frontline workers that were raised internally. Instead of these issues being investigated, employees were silenced, ignored, or punished. It should also be noted that the need for strong whistleblower protections has been a recurrent theme in inquiries, submissions, and reports relating to the PwC scandal that was uncovered in 2022. Existing oversight bodies lack the powers, resources, and mandate to effectively protect whistleblowers from reprisals or to enforce agency compliance. The CPSU did support the 2023 amendments to the Public Interest Disclosure Act, including strengthened protections for whistleblowers against reprisal. However, the architecture of the current scheme lacks the institutional support to give full effect to those amendments. The Commonwealth Ombudsman does not possess the power or obligation to independently investigate alleged reprisals or detrimental actions against a whistleblower, and it cannot take legal action or make binding orders against individuals or agencies to enforce those protections. It also lacks the necessary resources to carry out such functions. A Whistleblower Protection Authority would address that gap. This body must be fully funded and resourced to perform its functions effectively and independently. A second tranche of public sector whistleblowing reform must also provide greater support to employees who see wrongdoing and who call it out. Public sector workers shouldn't be forced to decide between their own job security and making disclosures. It's in the public interest for the Australian Public Service employees to be able to do both of those things. Potential whistleblowers need to be protected when they access support and advice from their union, which they cannot do right now. The CPSU calls for legislative reform to ensure that access to union support and advice does not compromise a whistleblower's protections under the Public Interest Disclosure Act. Seeking guidance from a trade union should be recognised as a legitimate and protected step in the disclosure process. This is consistent with the Moss Review and international best practice and reflects findings of the International Labour Organisation. The CPSU has long advocated for a robust, fair and accessible whistleblower protection framework, and a second tranche of whistleblower reform should include the following priorities: expanded coverage to include staff employed under the Members of Parliament Staff Act, as recommended by both the Moss Review and the Set the Standard report. Excluding these workers undermines the credibility of parliamentary workplace reforms and leaves a critical gap in protections. There needs to be strengthened external disclosure pathways, including protections for disclosures made to trade unions, support persons and parliamentary committees. Whistleblowers must be able to seek an advice and support without reprisal. The introduction of enforceable organisational duties similar to those in New South Wales to ensure agencies proactively assess and minimise the risk of detriment. Civil remedies must be available where agencies fail to uphold their responsibilities. The establishment of a fully funded, resourced Whistleblower Protection Authority with powers to support disclosures, monitor agency compliance and investigate reprisals. Oversight must be independent, consistent and effective. And finally, the simplification and clarification of the public interest disclosure framework, removing unnecessary technical barriers and ensuring protections apply to preparatory acts and disclosures made outside one's own agency. The CPSU urges the committee to consider these principles as a stronger whistleblowing protection framework. And thank you for the opportunity to address the committee this morning.
Thank you, Ms Fawcett. Mr Grest, I think you were going to go next.
Thank you very much. I just wanted to emphasise that the Alliance for Journalist Freedom, and thank you also for the opportunity to address the inquiry. We're part of the coalition of civil society groups, including the Human Rights Law Centre and Transparency International, because we recognise the fundamental role that whistleblowers play in holding governments accountable and underpinning the transparency, as we've so often heard today, to an effective democracy. Now, we think that the media is an essential part of that system, and it's got to be considered in any credible whistleblowing regime. We also underline that any effective whistleblower protection mechanism must maintain the integrity of what we've come to regard as the chain of disclosure. In other words, that protecting the entire process of whistleblowing, from gathering evidence of wrongdoing to having privileged conversations with lawyers to making protected internal disclosures, and where those mechanisms fall short, disclosing to a journalist and the journalist publishing the evidence. Now, if any part of that chain is compromised, the integrity of the entire system collapses. This is particularly important because the existence of a safe and credible system for whistleblowing that includes the media is itself a deterrent. Now, finally, while I recognise that this falls beyond the scope of the inquiry, I'd like to place on the record our view that this bill is just one part of an effective system of transparency and accountability that must also include legislative protections for public interest journalism. We've drafted a media freedom bill that creates a positive obligation for Parliament, the security and intelligence agencies and the courts to consider the public interest in publishing leaked information, including information from whistleblowers, alongside the more established public interest in prosecuting the sources of leaks. I'm happy, of course, to take questions on that issue, either here or on any other occasion. But in the meantime, I once again urge Parliament to take this long overdue opportunity to correct a flaw in our system of transparency and accountability and introduce an independent whistleblower protection authority. Thanks.
Thank you, Professor. I'm just checking with Mr Patrick. Yep, great. And I understand that you're having some connection issues, so if there are problems, feel free to let us know and we'll do our best.
I can hear you perfectly from here. We have, unfortunately, I'm in Dili, an impoverished nation that the Howard government took all of its oil supplies from. So, unfortunately, that's the situation we write. And if that comment's not out of order, because we know about this because of a whistleblower who eventually went on to be charged. I just really want to start by saying the Whistleblower Justice Fund has done a lot of work in this space. We've done some polling and right now on foot we have a petition with over 33,000 signatures calling for a Whistleblower Protection Authority. We know that our polling shows that 86% of Australians, and that is across all sides of Parliament or politics, Labor, Coalition, Greens and One Nation voters, 86% of Australians support whistleblower protection and 84% of Australians want a whistleblower protection authority. And we know there's lots of organisations that are appearing before you that also are organisations of great integrity and urging the Parliament to make a move on this. I might just, with indulgement, answer Senator Polly's question from the last session, where she asked about how we afford this. In my submission, you'll see the story of Tony Watson and who blew the whistle on Lend-Lease, and because of that, the tax office has received an extra $112 million in revenues, and that may well go to $300 million. Along the way, Tony Watson has lost his house as he's tried to do the right thing. The question is not how much is this going to cost, it's how much does it cost if we don't do it.
Thank you, Mr Patrick. We'll now proceed to questions, and I'll go to Senator Pocock.
Thank you, Chair. Thank you all for your time today and all your work on on this. My first question is for the Australian Institute. Mr. Brown, you talked about the public support for a Whistleblower Protection Authority. How does that compare to other integrity issues like the establishment of the National Anti-Corruption Commission?
On the whole, we see strong support from Australians for a variety of integrity measures. I don't have to hand the National Anti-Corruption Commission polling we did, but certainly when we've asked about truth in political advertising laws, you get consistently in the 80s or 90% support. The Whistleblower Protection Authority and whistleblower polling that we did showed similar levels of very high support from Australians. So as well as the kind of top level figures that have been mentioned, one of the things that was remarkable to me for the polling on legal protections for whistleblowers is how consistent it was across voting intentions. Labor, Coalition, Greens and One Nation, all within a couple of percentage points of one another in support. Another strong trend that we identify is the way that the polling testing support for whistleblower measures has increased over time. So with our partners, the Australia Institute's conducted this polling every 2 years since 2021. And when it comes to the question of whistleblowers making Australia a better place, 75% agreed in 2021, already a very strong result. But by 2025, that was 81%. So a very notable increase there over the ensuing years, something that might be related to the high-profile prosecutions of whistleblowers that we saw during that time. Similarly, in the 81% support for whistleblowers making Australia a better place, and we see an even more stark increase on the question of legal protections for whistleblowers, from 73% support in 2021 to 86% support in 2025. And I think the other thing to note there is that opposition is now only 5%. The gap between support and oppose is explained by a 9% don't know, not sure. But there are very, very few Australians who are opposed to whistleblower protections, very few Australians who see whistleblowers negatively.
Mm-hmm. Thank you. Mr. Patrick, I think you were online for the last session where we discussed some of the costs, and you talked about, in your opening statement, the costs of inaction. I was wondering if you could maybe expand on what you see as the costs from the absence of a Whistleblower Protection Authority, and maybe if you could just add to that, what difference you think a Whistleblower Protection Authority could have made to Richard Boyle's case?
Yes, thank you, Senator. The purpose of whistleblowing, first and foremost, is to deter misfeasance, malfeasance and corruption. That's the primary objective. It's not about assisting people to get someone. We just don't want that sort of conduct in our organisations. And a Whistleblower Protection Authority is a key part of that. We need to be able to support our whistleblowers. Most of the whistleblowers that I've talked with, and there have been many over time, they would tell you if they had to do it again, many of them wouldn't do it again, but if they had to do it again, they would do it completely different. There's a lot that is learnt along the way, and that would be the benefit of having a Whistleblower Protection Authority more generally, in that people can approach them and say, how do I go about doing this? How do I do the right thing? Now, in the case of Richard Boyle, he could have been helped all the way through his process. So he's pleaded guilty, and I say he pleaded very timidly. I was in the courtroom when he did. He's been in effect forced to plead guilty to preparing a public interest disclosure. Now, it's taken several barristers, several lawyers and 4 judges to work out whether or not he did the right thing at the start. Now, I'm not even sure a Whistleblower Protection Authority could have told them exactly what was and what wasn't correct, but they certainly could have cautioned him about the way he blew the whistle. He would also have been stewarded through the entire process. He's really suffered. It's been about 8 years of suffering for him and his family and those around him. He's not shy about some of the mental health issues that have flowed from the whistleblowing. So, the ability to be able to get support. And the other thing that's apparent to me is that no one, even the judges, don't think that he's a whistleblower and that he was acting in good faith, and yet he's been persecuted by the Australian Tax Office, and having blown the whistle, he just doesn't have the capacity to then turn around and deal with those who have worked against him and caused all of these issues. One would have thought that the prosecution that he's undergone is in fact a reprisal, and yet the tax office, those in the tax office that have pressed for this, will simply walk away, so a whistleblower protection authority could have assisted in right throughout his whistleblowing process.
Thank you, Chair.
Thank you. We've got a bunch of senators who wanted to ask questions, so we're in shorter blocks of time, and I'll go to the Deputy Chair.
Thank you very much, Chair, and thank you to the witnesses for appearing here today. I just have a couple of questions. First for the CPSU. Ms Fawcett, you've raised concerns in your submission about the APS Code of Conduct being used to silence whistleblowers. I'd be interested to sort of understand in a bit more depth why you think the Code of Conduct can be used that way, but also, if we are to accept that it's being used to silence whistleblowers, how would you change the Code of Conduct or balance the need for internal discipline and accountability with whistleblower protections, particularly, given the public service is often dealing with, politically sensitive cases? I'd just like a bit more context around that. Thank you.
Thank you, Senator. So the primary example here I have is the experience of our members during the robo-debt scheme. Our members in Centrelink at the time had the experience of directly raising their concerns with the scheme, using appropriate internal channels with their supervisor, and routinely told that the system is working as intended. So our members were scared about speaking out. In response to an anonymous letter at the height of the media focus on robo-debt, the agency sent out an all-staff email to employees, reminding them of the consequences of improper leaking and warning of repercussions. So that really did have a chilling effect on employees at the time. What staff understood was that if they raised concerns, that could impact on their employment. We did go into that question specifically about the APS Code of Conduct. We did see the weaponisation of the Code of Conduct there in that time. At one point, the CPSU issued an open letter to customers highlighting that our members, staff of Centrelink, had concerns about the robo-debt scheme. One union member who participated in that activity then faced a Code of Conduct investigation into their conduct. And ultimately, while a Code of Conduct breach was not found, that potentially could have threatened their employment and would have been a very difficult experience for that individual. Now, we would say under the current provisions that those actions of the agency could constitute reprisal action, but the difficulty here in the scheme is that there's a real lack of institutional support for enforcing those anti-reprisal protections in the public interest disclosure legislation. So a whistleblower protection authority with the power to investigate that kind of reprisal action would hopefully nip it in the bud, and we wouldn't see those sorts of threats being used against employees for legitimately raising concerns through internal channels.
So would your view be that it's not that the Code of Conduct needs to change, it's that a potential whistleblower protection authority should have the ability to perhaps not enforce, but have some sort of transparency measure over how the code of conduct, is being applied?
We would say that threats of code of conduct investigations could amount to reprisal action. So a whistleblower protection authority would have the power to and have the function of supporting agencies not to take that kind of reprisal action. And if that reprisal action was taken against an employee or group of employees, would have the power to investigate those sorts of that sort of conduct. So hopefully prevent it from happening, but certainly be able to take action if it did occur.
Mm-hmm. And one last question to the CPSU before I move on to another witness. You've called in your submission for significant staffing and funding for a potential whistleblower protection authority. What measures would you support to ensure that this new body remains efficient and cost effective and doesn't duplicate existing work of agencies like the Ombudsman or the NAC?
Yes, so the way that the bill is drafted, and we would support similar principles, is it sort of sits on top of existing whistleblower legislation and provides support for existing agencies to implement their responsibilities correctly. So it's not so much of a duplication, but a sort of facilitative function on top of existing laws.
And just a couple of questions to Mr. Patrick as well. In your opening comments and in the submission that you provided, you talked a lot about the cost of, I guess, the opportunity cost of establishing or not establishing a whistleblower protection authority. And I know that you cited some examples of where the actions of a whistleblower resulted in significant financial benefit to the Commonwealth. Do you have any further analysis in terms of what the cost of running this sort of authority might be, so that it's all very well to say, well, here are the rivers of gold that might be available to the Commonwealth if we have this authority, but realistically, how much does establishing this thing going to cost?
Yeah, look, there isn't any detail beyond the PBO estimates that Mr. Pender had talked about. But maybe if we can afford an AUKUS program, I think we can afford a whistleblower whistleblower protection authority. This is a relatively small amount of money in the context of the operations of government, and as you indicated, Senator Chandler, there has been money coming in as a result of the brave actions of Tony Wilson, the other. Sometimes whistleblowers don't necessarily stop activities that would otherwise generate money for the Commonwealth, but they also detect activity that would otherwise cost the Commonwealth. So there's a whole range of different ways in which to look at this. The cost of this is small, but the benefit to society is large, and indeed there can be revenue that can flow to the government. We've seen in the United States where significant benefit has flowed into consolidated revenue there in the order of billions of dollars. And we know that because we also see that in the United States they have a bounty scheme that can reward percentages of the money received. So all up, I think that the cost is minuscule compared to the benefit that flows from it.
Okay. Thank you, Mr. Patrick. Thanks.
Thank you, Deputy Chair. I'll now go to Senator Polley.
Thank you very much. I just want to take up where my colleague just left off. When we're talking about the cost of establishing this new standalone authority, the costing was done back in 2020, as I understand. So, and that costing hasn't been done against this bill. So, have you got any further updated costs, and I take on board what you're saying is that we should just spend whatever we need because it's going to be worth it. But we do have to look at whether or not this is the best model. So I'm trying to get some accuracy around the cost and the staffing levels. So if anyone can share a view on that, I'd appreciate it.
Well, I might start off, Senator Polly. You'll be aware that in 2019, the Labor Party went to the federal election with a with a promise, and that promise has been replicated in the Whistleblower Justice Fund's submission. Basically that promise was, and I'll read the headline, Labor will protect and reward whistleblowers, and it says, if elected, Labor will set up a whistleblower reward scheme, establish a whistleblower protection authority, overhaul our whistleblower laws with a single whistleblowing act, and fund a special prosecutor to bring corporate criminals to justice. I imagine that the Labor Party must have costed this itself and would have these sorts of details available as perhaps an alternate cost to the PBO information that's available.
Well, regrettably, in 2019 we weren't elected, and that was even prior to 2020 costings. So I appreciate your political points, but I'm actually trying to establish, in terms of the two new functions that will take place between in this bill, how much cost that is going to be, what the ICT cost is. So if you want to take that on notice, that would be great. If not, I'll move on to the Community and Public Sector Union, if I can.
Sorry, can I just, Chair, Senator Polly, Helen Haynes, the member for Indi's costings were done in 2025 this year, so I think they're fairly current.
That we've done this year?
Yeah.
Sorry.
I find it bizarre
Sorry.
that the government of the day has not done them themselves.
Thank
you for letting us know that Labor has not done that themselves.
Well,
jeez.
Sorry, can we just get back to
fair go?
Letting
Thank
Senator
you for
Polly
bringing us that point.
ask her questions of the witnesses.
Lack of interest.
Thank you. Thank you. Yeah, thank you, Chair. I want to go to the submission by the CPSU, and I note in that submission the importance of whistleblowers being able to access a union representative. Can you give us some examples of the CPSU's experience with whistleblowers that has highlighted the need for a whistleblower to be able to access union representation?
Thank you, Senator. And I have spoken about the standout example for the union being the experience of our members during the robo-debt scheme and the numerous attempts of frontline workers to call that scheme out and raise their concerns about the impact of that scheme on the most vulnerable Australians. So that is the sort of, the standout example from the union perspective. I would note that the Moss review into the Public Interest Disclosure Act did recommend that it should be easier for potential disclosures, witnesses and public officials to obtain help and support, and that includes disclosures being able to access advice and support from their union. So that has been recognised as an important step that does need to be taken. The review did recommend that the Public Interest Disclosure Act be amended to protect disclosures for the purposes of whistleblowers obtaining that advice and professional assistance, including from their union. So we would certainly be supportive of a step in that direction.
Thank you. I think I've run out of time.
Yep. Thank you, Senator Polly. I'll go to Senator Lambie.
Thank you. So if the bill, I'll ask, you can all contribute to this if you like, but I just want to know what your thinking is if the bill passes in its current form. What outcomes should Parliament expect within the first few years to judge whether the new authority is genuinely improving whistleblower protections? And can you, at this point in time, spell out the gaps in the NAC and current whistleblowers laws that show why this bill is needed?
I can jump in.
Thank you, Mr. Brown. Sorry, anyone you can jump in.
Tackle the first part of the question. I think what I'd be looking for in the first few years of operation of a whistleblower protection authority would be, firstly, evidence about the experience of whistleblowers in Australia. We've heard about just how personally punishing it can be to come forward. And so if there are evidence that the authority were sparing whistleblowers from some of the legal, emotional and professional consequences that we've seen directed at whistleblowers over the last few years, that would be a good sign that it was being effective. Depending on the kind of scale of the authority and whether a whistleblower reward scheme and so on were brought in, you might start to be seeing evidence of money saved by the Commonwealth. I'd be looking there not just at the amount of money extracted in fines and penalties against companies, but also that would give some impression of the harm that didn't occur at all, the deterrence effect that the authority was having. I think that can sometimes get missed when we look at the US figures of the $100 billion recovered from whistleblowers coming forward, is that there is an invisible sum of money that was saved by those offences being deterred in other cases altogether. And I'd be interested to see in the first few years whether litigation was kind of supported by the authority that could have tested the limits of current whistleblowing laws, could have answered for whistleblowers some of those questions about what the extent of the law is, because of course the experience of whistleblowers so far has been that they can in good faith think that they're complying with the laws and only discover afterwards that that's not the case.
Does anyone else have anything to contribute with that? No? Okay.
I can share the forms and back to you if you want.
Yeah, actually, can you?
I can do that.
Do that at this point in time.
Thank you. I'll now go to Senator Shoebridge and we'll return with a couple of minutes with Senator Lambie.
Thanks, Chair. I suppose my question is to but I might start with Mr. Grest. In some ways, having an effective whistleblower authority might cut some of the grass for the journalist classes, because instead of people going in desperation to a journalist, they actually may get their whistleblowing complaint effectively dealt with through an authority and through the agency. Peter, have you, in some ways, speaking against your self-interest as a journalist, aren't you? And maybe even reducing scandal by having good administration?
Senator, perhaps, but I think that the principal role of having the media there is as a whistle of last resort. And we know through countless examples that whistle has been effective. By having an effective whistleblower protection authority, I can see that, yes, there may be fewer complaints, fewer whistleblowers, fewer sources going to journalists ultimately, but I see that would be in favour of the current system of transparency and accountability, not necessarily against journalists' interests. I don't see that we are trying explicitly to improve the number of journalists, the number of sources that go to journalists. What I am trying to do is create, and what I see an independent whistleblower protection authority is doing, is helping make that system and helping the whistleblowers that ultimately do go to the media, doing so in a way that is protected, that has the kind of backup that they need when all of those other mechanisms have clearly failed. That has happened far too many times. We've seen many examples, and a lot of the submissions have cited those examples. There's David McBride, Richard Boyle, and Alan Kessing is another famous example of people who've gone to the media ultimately when the other internal mechanisms haven't succeeded. And I think that's evidence that an effective whistleblowing regime like the one outlined in the bill that we're considering has real potential to make the system more effective. And I think finally, and I want to go back to again some of the points that other submissions have made, and that is that this system needs to be credible. the prospect of blowing the whistle, not just internally, but ultimately externally to the media, has to remain credible. It has to be a viable path if those other internal systems fail. And a whistleblower protection authority that can aid that process, I think ultimately will help achieve the desired outcome.
And of course, when you're talking about blowing the whistle, a large part of the Commonwealth's expenditure happens in the national security space. We had some questions from the government earlier about ensuring that national security laws are still in place. We know from data from the National Anti-Corruption Commission that they've had, I think, at least 120 referrals to them from the defence space. How important is having whistleblowing for ensuring that the countless billions of dollars going into defence and national security and the apparatus itself is corruption-free and effective? And what are the challenges there that you've seen, Peter?
Look, the fact that so few of those whistleblowers, the ones that come out of defence, actually make it into the media, suggests that the people within defence, the national security intelligence agencies, take their responsibilities very, very seriously indeed, and don't take classified information into the media. Of course, that occasionally happens, and when it does, most of the time, it's done in a pretty responsible way. One of the things that, and again, I know that this does fall outside the scope of this inquiry, but our model for a Media Freedom Act includes protections, adequate protections for dealing with classified information. The other thing, and I made submissions to the Independent National Security Legislation Monitor's inquiry into secrecy laws, where the Insulant himself acknowledged that just because something is deemed to be classified, in and of itself, it isn't necessarily an indicator that its publication would be damaging to security. Regardless, there are those mechanisms in place. My view is that a whistleblower protection authority is in a much better place to shepherd disclosures and ultimately through to the media if necessary, but in a way that is respectful of the integrity of national security and confidential information.
I might just ask former Senator Patrick to respond to that as well.
Yeah, look, firstly, I don't think, just in relation to the first part, I don't think we'll ever put journalists out of a job. There's always controversies. It's a little bit like transparency. I was hoping that I might go out of business, but the government is actually helping me out a bit. My aim. I think it's stated on my website. My aim is to be put out of business. Look, the bottom line is that we need strong protection laws. We need to have a whistleblower protection authority as part of it. There's almost no downside in respect of this, and particularly in the defence space where we know there's huge amounts of money being spent, and the walls are thicker in and around defence. It's harder for us to see exactly what's going on inside defence, and the penalties are generally harsher. The Crimes Act directs severe penalties to people who do reveal classified information. That means we have to make sure we protect those who who are trying to do the right thing and are trying to call out where money is being improperly spent, or indeed, as we know, operationally, something's happening and it's not being called out.
In many ways, having an independent, well-resourced, capable set of hands to help whistleblowers deal with that is actually in the national security interest, isn't it?
Thank you, Senator Shoe. We just flagged.
Oh, absolutely.
Sorry.
Yeah, absolutely. Absolutely. We've seen instances, and I know you've mentioned in the Senate, where it is the conduct of people calling out war crimes, for example, actually assists our reputation and allows the confidence of our allies to work with us if they know that there are strong deterrents inside our own organisation to behave ethically and lawfully.
Thanks, Chair.
Thank you. And I want to thank each of our witnesses for taking the time to appear and give evidence today. If you've been asked to provide any additional information, would you please forward it to the Secretary by the 21st of August 2025? You'll be sent a copy of the transcript of your evidence and you'll have an opportunity to request corrections to any transcription errors. Thank you very much. We'll now take a short suspension while we welcome our next witnesses. I now welcome representatives from the Australian Human Rights Commission. Thank you for making time to appear before the committee today. Information on parliamentary privilege has been, and protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of the Department of a Commonwealth or state or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appear?
Thank you, Chair. Commissioner Lorraine Finlay, Human Rights Commissioner with the Australian Human Rights Commission.
And Chair Graham Edgerton, Deputy General Counsel, Australian Human Rights Commission.
Thank you very much. Would you like to make a brief opening statement before we proceed to questions?
A brief one, please, Chair. Well, firstly, thank you to the committee for the invitation to provide evidence today. Whistleblowers provide a vitally important public service. They identify issues of maladministration, corruption and other wrongdoing so that they can be addressed and remedied. Unfortunately, as we've heard in evidence this morning before this committee, blowing the whistle often comes at great personal cost. Whistleblowers can face reprisals and recriminations for doing the right thing. This might include bullying or harassment, termination of employment or counter-investigations into their own conduct. As a result, it is important that they can easily access information about how to make a disclosure and that they are protected for doing so. The Australian Human Rights Commission supports the establishment of an independent whistleblower protection authority. We've identified 3 key functions for such an authority. These functions are broadly consistent with those recommended in 2017 by the Parliamentary Joint Committee on Corporations and Financial Services. First, it should act as a clearinghouse for whistleblowers making public interest disclosures. Establishing a central one-stop shop would make it clear to whistleblowers who to approach and would facilitate reports being referred to the agency or entity that was best placed to investigate. Secondly, it should provide advice and assistance to whistleblowers. The current environment for whistleblowers is complex and differs between sectors. There is a real need for access to clear, independent and expert advice about how to make a report, what the process involves, the potential risks and how these can be addressed. Thirdly, it should have the power to investigate allegations of reprisals. We understand from the written submission of the Commonwealth Ombudsman to this inquiry that it can investigate reprisals in the public sector in certain circumstances. However, the process is not clear in the legislation and it appears that the Ombudsman currently has limited capacity to carry out investigations. There are considerable advantages to establishing a standalone whistleblower protection body. Importantly, it would be well placed to cover issues in both the public and private sectors, driving increased consistency and clarity of protections. A well-resourced authority would be able to quickly and proactively respond to actual or threatened reprisals. The current bill provides a useful guide as to how a whistleblower protection authority could operate. For the reasons set out in more detail in our written submission, we consider that the bill is not currently in a form that should be passed. However, we recommend that the government introduce its own legislation to establish a whistleblower protection authority. One element that is missing in the bill that should be part of any new proposal is ensuring that when a whistleblower makes a disclosure to the authority, they immediately receive the same protections as if they had made the disclosure under the relevant whistleblowing legislation. We refer to this as the no wrong doors approach. Thank you again for the invitation to provide evidence this morning, and we invite any questions from the committee.
Thank you, Commissioner. We'll proceed to questions and start with Senator Pocock.
Thank you both for your time. Dr. Finlay, what changes to the bill could be made to better balance the Whistleblower Protection Authority's role in coordinating and overseeing investigations with the need to avoid conflicts of interest?
We've addressed that, Senator, and thank you for the question, specifically in the written submission, and go in in some detail to specifics that we think need to be considered. But in particular, the main concerns that we have can be divided out into three. The first is that ensuring the functions given to the Commissioner don't duplicate work of other regulators. Secondly, ensuring that where the bill, which borrows quite heavily from the NAC Act in terms of the proposed investigatory powers, so making sure that those powers are appropriate for a whistleblowing protection authority. But thirdly, ensuring that when you think about the broad range of functions that the Commission could have, being regulatory, impartial dispute resolution and adversarial, that any conflicts of interest are appropriately managed. And certainly there are examples, and the Australian Human Rights Commission is one, where different types of functions can be managed in an appropriate way, but that is something we do think needs to be set out in greater detail in the bill. And I might ask my colleague if he has any comments to add.
Senator, it's probably the third of those functions that creates the most concern, the sort of more proactive adversarial functions, and just balancing that with an agency that you want to make sure has integrity as an impartial regulator. So the idea of sort of giving specific advice to individual whistleblowers about their circumstances and what they should do, or individually representing whistleblowers and taking instructions from them in litigation, maybe, as opposed to taking a more regulatory approach of intervening as a regulator in existing legal proceedings and making submissions about the structure of the legislation and sort of general principles rather than taking sides.
Thank you. And your submission also raises concerns about possible infringements on the rights of individuals involved or implicated in investigations. How could the Whistleblower Protection Authority have strong investigatory and enforcement powers whilst also protecting the rights of those implicated in investigations? How do you see that sort of balance working?
Sorry, Senator, could you clarify the question for us?
So in your submission, you raise concerns about possible infringements on the rights of individuals involved or implicated in investigations. So I'm interested, how do you think a Whistleblower Protection Authority could balance, I guess, those having strong investigatory processes whilst also balancing sort of the human rights of people being investigated?
I don't have a single answer in terms of one thing that could be done to precisely address the entirety of that concern, Senator, but it really does go to the point that we make in our submission about all of these different functions needing to be carefully thought through. And one of the issues we do raise, for example, is transferring those investigatory powers from the NAC directly across to the whistleblowing authority without really thinking through whether the functions are exactly the same or how they would work in this particular context is something that needs some additional thought. And again, I'd really like to frame that answer in the broader context of a whistleblower protection authority is something that the Commission in principle does support and does think would make an important contribution, particularly in light of the evidence that we've heard this morning. So I want to ensure that the concerns and issues we've raised in our submission don't detract from that underlying point. Our view is this is a proposal whose time has more than come, but it is important to ensure those detailed issues are thought through so that when the authority does take its place, it can operate as effectively as possible and have the full confidence of the Australian community behind it.
Thank you. Thank you, Chair.
Thank you. I'll now go to Senator Polley.
Thank you very much for appearing before us. So can I just ask what sort of interaction does the Human Rights Commission have with whistleblowers?
We're not a regulatory body for whistleblowers per se, so primarily that function would be carried out by the Commonwealth Ombudsman, but potentially if a whistleblower in the course of blowing the whistle or having reprisals made against them had their human rights breached, they could make a complaint to the Australian Human Rights Commission about that.
Can I ask then, within your submission you raised concerns that some of the functions given to the Whistleblower Protection Commission under the bill would duplicate the work of other regulators, which I've asked questions and other panel members have asked questions. So what are the key areas of concern of duplication that the Human Rights Commission have?
So I think it was primarily looking at the oversight that the authority would have about investigation of the substantive issues underlying the disclosure. So I think the bill anticipates that the Whistleblower Protection Authority could act as that clearinghouse, refer a matter out for investigation by another authority, but then oversee the conduct of that investigation. When there are other agencies that already have those functions of overseeing the conduct of investigating disclosures. So the kinds of authorities that we're thinking about are the Ombudsman, IGIS, the Australian Taxation Office. So would the Whistleblower Protection Authority be duplicating some of those oversight functions from those other regulatory agencies?
I refer again to your submission that indicates that the bill borrows heavily from the National Anti-Corruption Commission Act for the administrative structure and proposed investigatory powers. It also notes that more consideration would need to be given whether the suite of very intrusive investigation powers available to NAC was appropriate for a Whistleblower Protection Authority, primarily focused on issues of reprisal and victimisation directed at whistleblowers. Can you just explain to the committee what the significant issues around those powers are that you're referring to?
So the bill proposes that the Whistleblower Protection Authority would have the same investigatory functions as the NAC. So I think the bill kind of picks up all of those investigatory powers in one section, and there's quite a lot of detail in the NAC Act about the powers that the NAC has. The NAC's got very extensive investigatory powers, and I guess the only point that we were making was you would need to consider whether all of those powers were appropriate for the Whistleblower Protection Authority, given the scope of what the Whistleblower Protection Authority is intended to do, which is largely looking at issues of reprisals. So, for example, the NAC has the ability to ask the court for orders to cancel someone's passport. Would that be appropriate for the Whistleblower Protection Authority? Can you envisage circumstances in which that would be necessary? Obviously, if they did have that power, it infringes very significantly on people's right to movement. The NAC Act also incorporates a large number of criminal offences for sort of non-compliance with administrative steps. Is that appropriate for the Whistleblower Protection Authority as well? It just wasn't clear to us that those issues had really been thought about in the bill. Now, that's not to, as the Commissioner says, to criticise the objective of the bill overall. It was really us sort of going into some of the detail of the bill to work out whether this particular model for a Whistleblower Protection Authority was the best model available.
And if I could just add to that, Senator, our view is, sorry to interrupt, our view is the bill would be strengthened by ensuring that those issues are well thought through in advance. Now, it's important to strike a balance. This shouldn't delay the introduction of an authority because it is something that has been on the table and discussed for a very long period of time, but it is important that level of detail is thought through ahead of time, again, so that the authority can operate with maximum effectiveness once it's introduced.
And my final question comes to conflicts of interest, and I think you alluded to that in your submission about the functions of the authority. So what would your concerns be around any conflict of interest that you foresee with this bill?
Thank you, Senator. I think part of that answer is the answer that I gave to Senator Pocock before. There's sort of three sets of functions that we see this bill giving to the authority. Part of those are kind of regulatory and investigatory powers. Part of them are kind of impartial mediation, dispute resolution powers. And then part of them are sort of much more adversarial powers where you're acting for the whistleblower or providing detailed advice to the whistleblower. We think it's really important that the Whistleblower Protection Authority be seen as impartial and credible in that kind of sense, and not be seen as being compromised in some of those regulatory and potentially dispute resolution areas of its work by seeing as being too partisan for particular individuals in a particular case. It might be difficult for them to maintain that reputation, but also there might be real logistical issues if information that comes in a confidential dispute resolution phase would then have to be quarantined from being used in a much more adversarial setting.
And again, could I just emphasise, Senator, that from our perspective, none of those issues are insurmountable, but they are issues that need to be addressed.
Thank you, Chair.
Thank you, Senator Polley. Senator Shoebridge.
Well, thanks, Chair, and thanks for the submission. Of course, you would already experience often overlap with other agencies' powers in the work that the Commission does. I imagine there'd be multiple occasions where you're undertaking a review of something that has the Ombudsman might already be working on an aspect of it. It may have already gone as a complaints process to the Public Service Commission, and in some cases there may even be a police complaint out. And that kind of overlap of different oversight agencies is already a feature, isn't it?
There's certainly an overlap in jurisdiction, but a lot of our legislation tries to deal with that in terms of referrals from one agency to another, or ensuring that if a matter has previously been considered by one agency and dealt with, that it's not subsequently dealt with by us again, so there's not that kind of double handling. But I think
there are those referral powers in this bill, and indeed when considering whether to undertake an investigation, the authority has to take into consideration whether another agency or another body is better equipped to deal with it, is already dealing with it. I mean, that's part of this bill, isn't it?
That is part of the bill. I think that the duplication issue that we were more concerned about was the issue that I raised before about whether this agency would oversight other investigatory agencies doing their role. So the bill, there's two types of matters that the bill deals with. One is kind of disclosures of substantial wrongdoing, and the second one is whistleblower protection issues. And we see this agency, the primary function is dealing with whistleblower protection issues, but the bill as it's currently drafted has quite a number of sort of extensive powers really for this agency in relation to oversight of substantive investigation into substantive disclosures, and that's where we saw the overlap being, because there's obviously a lot of other integrity agencies currently that have those roles.
But if a particular, if there's a whistleblower has come to the agency, come to the authority has done a preliminary investigation, worked with the agency, and the agency then says it's going to address it by an internal investigation, having the whistleblower authority remain in the space to ensure that the investigation is done with objectivity and integrity, that's a far from unusual power. You would find those same kind of powers in state police oversight bodies across the entire country, wouldn't you?
Potentially, but the bill would also allow, for example, if referral was made to the Ombudsman and the Ombudsman was conducting the investigation into the substantial disclosure, The bill would allow the Whistleblower Protection Agency oversight of the Ombudsman's investigation of the substantive disclosure. And that's where we think maybe there's too much duplication being involved. Now, again, maybe these aren't insurmountable problems. Maybe there's amendments that can be made. But in terms of trying to go through this bill thoroughly and identify what the benefits were or what the potential problems were, that was one that we'd identified.
And if I could perhaps just add in, Senator, it is for us really a matter of finding that right balance, recognising that on the one hand, part of the purpose of establishing this authority is to avoid any gaps. But on the other hand, part of the purpose is to ensure a clearer, more straightforward, accessible process for whistleblowers. So we don't think any of these things are insurmountable. Some of them may in fact be features of the legislation in terms of what the authority is intended to do. But from our submission, we have raised a few issues that we don't think have been really thoroughly considered in detail and would need to be given just some further thought before it was introduced.
Well, I'll come to some of your concerns about the scope of the compulsory powers in a second. But when it comes to the idea that a whistleblower's authority would spend its scarce resources, and I'm pretty sure, Commissioner, you understand how scarce resources are in the Commonwealth integrity oversight. And stop me if I've got a misapprehension here. But any authority that has scarce resources is hardly going to be spending them pointlessly oversighting an investigation, say, by the Ombudsman or an investigation by another statutory body. At some point, the legislation needs to recognise there's scarce resources, there will hopefully be good administration and sensible organisational goals for how they use those scarce resources. You can assume that there'll be some of that, can't you, Commissioner?
Oh, I think you certainly can, Senator, but I'd also say it's a preferable situation to have those assumptions underpinned by a clear legislative framework that encourages that approach to be taken. I'm not saying that's not the approach in this bill. All we are saying is that there are some issues we've identified that could strengthen the bill by just giving some additional thought to them.
So an amendment to the effect that to be mindful to not duplicate resources and to put those kinds of sort of statutory mindfulness in the bill would be a step forward, wouldn't it?
I think it would be, in addition to the specific issues that we've raised in our written submission in considerable detail.
All right. Well, in terms of the compulsory powers, you've indicated, I think, some of the NAC powers may be unnecessary. But if there is to be an investigative power in the agency, some powers, such as compulsory production of documents, summonsing of witnesses, some of those powers are necessary in an effective investigative body, aren't they?
Yes, Senator, of course.
Could you, on notice, just advise what powers you think, what that sort of core set of powers that are necessary for an investigative body are, and maybe those that the NAC has that you think would be, excessive or surplus are, so as we get some understanding of where you think the line should be drawn.
And just to understand the context, Senator, you'd be asking that question with reference specifically to a whistleblower protection authority, not an investigative body, more generally in relation to any issue?
Yeah, this authority with the purposes it's been established to do. I'll ask you to take that on notice, unless you can specify them now.
Well, happy to take it on notice, but obviously production of information and production of documents is a standard investigatory tool. I guess one concern we had with the way in which it's framed currently is ordinarily you would have a administrative process to do that. So you'd issue, for example, a compulsory notice to produce, and that notice would have formal requirements. You could test it for validity, you could test whether it was in scope or not. But I think the current drafting just suggests that there can be a requirement that information is produced, and none of that kind of machinery was around it. But obviously, as you say, requiring production of information and documents is a standard investigatory tool, and we would expect that this authority should have that.
You've said that the net is cast too wide by giving the NAC powers. If you could just articulate what powers you think are outside of where a reasonable net should be cast, that would be useful. Could I just ask you to focus on one other aspect of the bill, which is you say if they have a role in assisting whistleblowers and they're seen to be in the whistleblower's corner, then they need to ensure that if they then have a separate role of prosecuting wrongdoing, that they're not seen to have a conflict of interest, and that the information that they obtain in assisting whistleblowers, perhaps through the use of compulsory powers, isn't contaminated in such a way so that they can't effectively be an independent prosecutor. That could be addressed, couldn't it, by having very clear organisational barriers for information, and perhaps even maybe an independent commissioner who undertakes the kind of prosecutorial roles, but some kind of clear organisational barriers to the flow of information and organisational structure that creates that independence. That's very much achievable, isn't it?
Well, certainly we don't believe any of these things are insurmountable. There are examples of that given in the Dutch model, if I'm not mistaken, and not quite a direct analogy.
Commissioner, I'm going to ask you, can you tell us the name of the Dutch whistleblowing authority?
I actually can, but not off the top of my head, Senator.
My Dutch is so bad, it's like 17 syllables long.
And I have Dutch heritage, so it's embarrassing that I can't give it to you directly off the top of my head. However, I would also give a direct, not a perfect analogy, but a relatable one in terms of the role of the Australian Human Rights Commission with our complaint and conciliation function, which is by legislation kept quite separate from the commissioners. It resides in the President, and there are legislative measures expressly in our legislation that limit that to the President and remove the commissioners from that role. But if I could give you a direct example from the bill, one of the points that we did note is if you have a look, for example, at the role around the Section 36 proceeding and applications and the ability of the Commissioner to provide or arrange for the provision of legal advice in relation to whistleblowers, but then the mediation and arbitration role in Section 37, which suggests that the Commissioner could potentially provide legal advice as appropriate to any person involved in a mediation or arbitration. There would just be a need to, again, think through any conflict issues and ensuring that those adversarial functions and conciliation functions are appropriately calibrated, which could be done either through internal mechanisms being in place or through a separation of the functions in legislation.
And replicating provisions similar to are found in the Commission's legislation would go a significant way to dealing with that concerns you have about ensuring the separation and the absence of improper information moving from A to B.
It would be one way of dealing with it. The only consideration that I would raise is that ensuring that the Whistleblower Protection Authority then has that broad public confidence attached to it. One of the things that we are very conscious of at the Australian Human Rights Commission is there isn't always a strong public understanding of the way that plays out in practice. And so there, I think, would be a need for that to be given some additional thought.
And I guess the structure of the... Apologies.
No, you go.
The structure of the Australian Human Rights Commission probably is a good example of multiple functions being brought within one organisation, but it's not quite as broad as what's envisaged by the bill. So, for example, with the Australian Human Rights Commission, we've got a National Information Service. People can call up and ask for general information about human rights or discrimination law, and that will be kind of provided to them. There's a conciliation service for disputes. So if someone makes a complaint of a breach of human rights or of discrimination law, the first step is conciliation within the Commission before you go to court. But the role of the conciliators is impartial in that process. They're not acting for either of the parties. And what they're trying to do is bring the parties together to try and reach an outcome so that litigation isn't ultimately required. The Commission does have a function of intervening in cases that raise human rights issues, but when it does that, again, it's not acting for any of the parties in that litigation, and usually it's, in a sense, assisting the court in interpreting the relevant legislation. So there is a real importance for the Commission in being seen to be impartial in the way in which it exercises those functions. Some aspects of this bill, I think, maybe go over that line in the sense of advising individual parties about the course that they should take, or potentially taking instructions from those parties in the conduct of litigation.
But of course, that is informed, isn't it, by the experience of so many whistleblowers, that the complexity of the legislation, a potential misstep, and not having that guidance as they work their way through a public interest disclosure is leaving them open to prosecution and not providing the kind of integrity and checks we need for whistleblowers. That's informed by experience, isn't it? Which explains perhaps the extent of the bill.
It is, Senator, and that's where, on our reading of the bill, there are a number of very important different functions that the authority is being potentially charged with, which is why it's so important to think through that detail and make sure either that those functions are separated out or that there are sufficient inbuilt protections that we can avoid those issues of potential conflict.
Thank you,
And I
Senator
was hoping
Shoebridge.
you were going to say, Commissioner, who's or clock includers or whatever, much better than I did. So I give you one last opportunity.
Senator, I would not want to get my pronunciation of that wrong.
All right, thank you, Senator Shoebridge, and I thank our witnesses for appearing to give evidence today. You have been asked to provide some additional information. Would you please forward it to the Secretary by Thursday the 21st of August 2025? You'll be sent a copy of a transcript of your evidence and will have an opportunity to request corrections to any transcription errors. We are now going to break for morning tea and return at 11:30. I now welcome representatives from Clayton Utes. Hopefully I've said that right. Clayton Utes and Thrive Integrity. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. For the Hansard record, would you please state your full name and the capacity in which you appear? I'll start in the room and then I'll go to online.
Lauren Witherden, Principal, Thrive Integrity.
Thank you. So I can't hear you there. You're not on mute. No. Can I try again? No. Right.
I'll try this one.
Oh, there you go. There we go. Got you.
There we go. Fantastic. Got three options here. You've got Amanda Lyer as partner at Clayton Utes.
Excellent. Thank you very much. Would either of you like to make a brief opening statement? Ms Witherden is in here nodding her head, so I'll start with you.
Okay. Chair and Senators, thank you for the opportunity to appear today. We welcome the introduction of the Whistleblower Protection Authority Bill 2025 No. 2 and support the establishment of an independent Whistleblower Protection Authority. My comments draw on over 20 years' professional experience in whistleblowing, working with organisations in the private, public and not-for-profit sectors. Australia's whistleblowing laws are fragmented and complex, creating challenges for those who speak up and the organisations that receive their reports. A dedicated authority presents an opportunity to assist individuals in navigating this complexity while strengthening Australia's integrity framework, delivering better outcomes for individuals and organisations alike. Global research shows organisations lose around 5% of revenue to fraud each year, with whistleblower tip-offs accounting for 43% of detections. Applied to the Australian economy, that equates to potentially billions of dollars in losses, many of them preventable. Establishing a strong whistleblower protection authority could improve the detection of fraud, corruption, unsafe work practices and other misconduct, while ensuring those who speak up are protected, strengthening both integrity and economic performance. This bill is a significant step forward. However, greater clarity is needed on how the authority will operate in the private sector and interact with internal whistleblower programs. Our submission highlights 4 elements key to success: reinforcing and supporting effective internal reporting channels so issues can be addressed early, ensuring proportionate and scalable approaches that meet the needs of diverse organisations, investing in training and education to build capability at all levels, and driving cultural change through setting better practice standards. I welcome your questions. Thank you.
Thank you. And Ms Laris, would you like to make an opening statement?
Yes, thank you. Thank you, Chair and Senators, for the invitation to appear before you today for this important discussion. At Clayton Utes, we have extensive experience advising a variety of organisations on the operation of whistleblower laws, including in the context of complex whistleblower disclosures, investigations and litigation. We also support our clients in developing whistleblower policy and procedural frameworks that support compliance as well as best practice. While we have a number of clients who are subject to public interest disclosure regimes, we have particular expertise in advising regulated entities under the Corporations Act. And I've previously been invited by the Senate Economics Committee to give evidence in relation to the development of the current whistleblowing protections in the Corporations Act. Against that backdrop, we welcome the bill's intent to strengthen supports and protections for whistleblowers and to promote compliance and education in this critical area. However, we believe there are opportunities for the bill to be further developed in terms of its application to the private sector in particular, and to clarify its operation and ensure consistency with existing legal frameworks. Our submission highlights several key areas for improvement, and I'd like to highlight a few of those today. First, we recommend aligning the scope of a whistleblower protection issue that may be raised with protections under existing whistleblowing laws, and ensuring that whistleblower protection responsibilities that are required to be upheld by a person reflect existing legal duties and do not encompass discretionary responsibilities under company policies in the private sector that may vary between organisations. These changes would support clarity and consistency in operation. Secondly, we recommend measures to ensure private sector organisations are appropriately informed about the receipt and management by the Commissioner of whistleblower protection issues that concern them, subject to appropriate caveats. This would provide organisations with an opportunity to take proactive steps to support whistleblowers who may be engaging with the authority and to cooperate with the Commissioner in relation to a whistleblower protection issue. Finally, we recommend ensuring that the Whistleblower Protection Commissioner has an appropriate range of grounds to support a decision to take no further action in relation to whistleblower protection issues. And we recommend that any disclosure of whistleblower protection issues dealt with by the Commissioner is subject to the confidentiality requirements set out in applicable whistleblower legislation. We believe these refinements will ensure the bill achieves its objectives effectively without unintended consequences and will provide clarity and certainty for organisations. I'd be pleased to elaborate on these points or address any questions that the committee may have today. Thank you.
Thank you very much for those opening statements. We'll now proceed to questions, and I'll go to Senator Pocock.
Thank you both for your time. Ms. Lyris, I have a question about how an independent whistleblower protection authority could help reduce the regulatory burden of Australia's complex and overlapping whistleblower laws on the private sector.
Thank you, Senator. As you've alluded to, there is a complex patchwork quilt of whistleblowing laws that apply across the private sector, ranging from the Corporations Act through to other discrete pieces of legislation, such as the Aged Care Act and so forth. The framework is complex, and in my experience, organisations will deal with whistleblowers who may not be aware of how those regimes operate or what rights and protections they may be able to access under those regimes. And certainly I see that a whistleblower protection authority could play an important education role in that context and supportive role in helping whistleblowers to understand how protections apply to them, the types of things that they may raise in line with those frameworks, and also how organisations can best support whistleblowers from a guidance perspective in addition.
Thank you. Ms. Witherden, what measures do you think could be included in the Whistleblower Protection Authority bill to avoid duplication of internal whistleblowing programs?
I think it's really important that we don't duplicate internal whistleblowing programs, but I think there's an opportunity to go further than that and actually have the Whistleblowing Protection Authority's function to also extend to supporting and uplifting organisational whistleblowing programs, because at the end of the day, that's going to be a better use of government resources if we can equip and support organisations to have effective programs themselves in the first place. In terms of measures that can be taken to avoid duplication, I think that it will be important to have regular communication between the authority and organisations and industry groups. That will be key. And I think as well it will be very important that the authority is able to reinforce the internal reporting channels at the point of receipt of disclosures. So rather than blindly taking forward a disclosure that comes to the authority, I think that there is good sense in conversing with the whistleblower around their awareness of the channels available to them and also their reason for wishing to go direct to the authority, if indeed that is their intention, and whether they may feel comfortable using their organisational whistleblower, perhaps under the oversight of the authority.
Thank you. Ms. Lyris, do you agree that an authority like this could work alongside and actually complement internal processes that companies may have?
Absolutely. I agree with Ms Withern's comments. I think it would be a missed opportunity for the authority not to work collaboratively with organisations where that is possible. Organisations are typically best placed to be able to address issues that may be raised in relation to their business, and I see that the authority can play a very valuable role in supporting whistleblowers to access relevant channels and to accompany them through that process as needed.
Thank you. Thank you, Chair.
Thank you. I'll now move to Senator Polley.
Thank you, and thank you both for appearing before us in your submissions. I just want to go to Thrive. What services does your organisation actually offer to the whistleblowers?
So Thrive is engaged by organisations rather than whistleblowers themselves. However, in my prior roles working in the whistleblowing field, I have led whistleblowing hotline services for both a Big Four firm and a leading provider. And that has provided me with the privilege of having directly spoken with and reviewed the report of many, many whistleblowers over the years. And I very much find this background is useful to me in helping guide and support organisations to have better practice and effective whistleblowing programs.
Thank you. On your website, you indicate that your experience enables you to address the unique challenges of each sector. So if we look at corporate Australia, government and not-for-profit organisations, can you describe for the committee the unique challenges that different sectors face when dealing with whistleblowing issues?
There are themes around the types of matters that tend to come through whistleblowing programs depending on the sector. And so whistleblowing programs tend to be more successful in my experience when they're able to be aware of those themes and cater to them. Also, the size of the organisation. So large ASX-listed organisations, financial services, for example, mining, large retail organisations and large public sector agencies tend to be dealing with a much higher volume of disclosures, which comes with different challenges compared to organisations perhaps in the not-for-profit industry or smaller-sized organisations where volumes are much lower in my experience, and a lot of the challenge is really around instilling a culture where individuals are willing and able to use the program.
Right, thank you. And because I've got shortness of time, I can go for our other witness. In your submission, you actually indicate that there's some functions of the Commissioner which appear to extend beyond the powers of the Commissioner set out elsewhere in the bill and have potential to create an overreach and even conflict. So I just wondered if you could talk us through those provisions and where you see the key concerns are.
Sure, thank you, Senator. My comments in the submission were directed to ensuring that where the Commission's powers are developed in greater detail in other parts of the bill, that where they are referred to at the outset of the bill in summary, that those summary provisions are expressed to be subject to the further detail that's elaborated upon. So, for example, Section 36, subsection 2 of the bill states that the Commissioner may, in respect of a whistleblower protection issue, if satisfied it's in the public interest to do so, may commence proceedings in a court or make applications to an industrial, civil or administrative body seeking orders that may be available under a Commonwealth law for remedies for a breach or apprehended breach of whistleblower protection responsibilities. That power was narrower than simply commencing proceedings or making applications to enforce the bill or any Commonwealth laws, which was provided under Section 10, subsection O of the bill. So it was essentially a drafting point just to ensure that the powers of the Commission and the authority are clear and consistent throughout the bill.
I think, good point. Can I go to your recommendation 11 which suggests that any disclosure of whistleblower protection issues under the bill should be subject to confidentiality requirements. Can you step us through the reasoning behind this recommendation, please?
Of course. So the two key fundamental protections that typically arise under the various whistleblower legislation in place relate to confidentiality, so protecting the confidence of the identity of a whistleblower, and separately to prevent them experiencing victimisation. The confidentiality protections are relatively strict under the main pieces of legislation. In the Corporations Act, it essentially prohibits disclosing identifying information or information likely to identify a whistleblower. And in practice, that can be simply referring to the nature of matters they may have raised, where only a small subset of people may be aware of those matters, or in circumstances where that individual may have raised those matters with other people in other forums and contexts. And so in my experience, when I work with organisations around managing whistleblowing disclosures, one of the key things that often presents complexity is ensuring that steps are taken to essentially de-identify whistleblowers, particularly where they don't wish to be identified expressly, to ensure that matters which may, for example, be investigated or reported on have been sufficiently anonymised to protect their identity. In terms of the Commission's powers and various matters that the bill provides for, one example is the annual report that will be prepared with respect to whistleblower protection issues that are raised, and our comments were really directed towards ensuring that any material that is released into the public domain, for example, under an annual report, has been appropriately anonymised or de-identified in line with those broader confidentiality protections that may apply.
Thank you for that. Thank you, Chair.
Thank you. I believe that's all the questions that we have for you today, but I want to say thank you for taking the time to appear to give evidence today. If you've been asked to provide any additional information, would you please forward it to the Secretary by the 21st of August 2025. You'll be sent a copy of the transcript of your evidence, and you'll have an opportunity to request corrections to any transcription errors. Thank you very much. We're going to take a short suspension while we welcome our next witnesses. On parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appear? And I'll start in the room and on the left.
Carmen Miragaya, Director of the Public Interest Disclosure Team at the Office of the Commonwealth Ombudsman.
Ian Anderson, Commonwealth Ombudsman.
Thank you.
Rebecca Omar, General Manager Legal at the National Anti-Corruption Commission.
And Philip Reid, CEO of the National Anti-Corruption Commission.
Thank you. And we'll go to the New South Wales Ombudsman.
Hello, Chris Clayton, Senior Deputy Ombudsman, New South Wales Ombudsman's Office.
And Chris Banks, Manager, Whistleblower Support at the New South Wales Ombudsman's Office.
Thank you. And to ASIC. Do we have ASIC online? Chris?
I'm the Executive Director of ASIC's Enforcement and Compliance team.
Thank you.
And I'm Greg Hackett. I'm a Senior Manager in ASIC's Companies, Registered Liquidators and Small Business team.
Thank you very much. Is there anyone who would like to make a brief opening statement? Yes. Thank you, Mr. Reid.
We provided this for the record, but I just wanted to start by saying that the Commission didn't make a submission to the inquiry into the Whistleblower Protection Authority Bill, though we welcome the opportunity to attend this hearing and answer any questions. But as a result of not putting in a submission, we just thought there were some elements that would be important to raise here and now rather than just have it on the record. So while some individuals are mandatory referrers under the NAC Act, and they must refer corruption issues of which they become aware to the Commission, anyone can make a voluntary referral to the Commission. This means that the Commission's jurisdiction is focused on public officials, while the Commission's jurisdiction is focused on public officials, anyone who makes a referral to the Commission attracts the protections that are afforded under the NAC Act. Accordingly, the Commission recognised the importance of whistleblowers in combating corruption. Corruption is often conducted secretly depending on private influence and contact. For this reason, whistleblowers can play a critical role in exposing corruption and other conduct that would otherwise remain undetected and ultimately in holding those responsible to account. Appropriate protections for whistleblowers are therefore important to facilitate, support and encourage the reporting of corrupt conduct by those most likely to have information about it. It's important that protections available to whistleblowers are clear and unambiguous so that potential whistleblowers can make informed decisions so that disclosures are aware of and can invoke their protections, and so that those who might contemplate adverse action against the whistleblower are deterred. The NAC Act protects persons who make disclosures to the Commission from liability and reprisal. It also protects the confidentiality of their identity. Part 4 of the NAC Act provides protections for disclosures under the NAC Act from liability and reprisals. In particular, any person who makes a referral, provides information or gives evidence to the Commission about a corruption issue, and that makes it a NAC disclosure, is protected from all civil, criminal or administrative liability, including disciplinary action for doing so, and no contractual right or remedy can be taken against them. It's a criminal offence for anyone to take or threaten to take reprisal action of any kind against a person for making a referral, providing information or giving evidence to the Commission. Of reprisal is when a person causes other person's detriment because they believe or suspect the other person has or may or could disclose a corruption issue to the Commission. Where a witness provides information to the Commission as a result of the use of the Commission's coercive powers, this information is also a NAC disclosure and thus attracts the liability and reprisal protections. In addition, it's an offence for Commission staff to make a record of or disclose information obtained in the course of their duties unless permitted to do so by an exception under the NAC Act. To date, the Commission has not, as a matter of practice, identified any issues with the operation of these protections. In its first 2 years of operation, the Commission has received 5,400 referrals, including 220 mandatory referrals. Of these, 4 of the mandatory referrals were made under Section 35 of the NAC Act, being mandatory referrals from PID officers who become aware of a corruption issue. Ultimately, whether there should be a Whistleblower Protection Authority in the form it should take are questions for Government and this Parliament. In relation to any interactions between a proposed authority and the Commission, it's important that the Commission's independence is maintained and investigations are not prejudiced. Thank you.
I'll make a very brief opening statement. My agency has a particular role with respect to the Public Interest Disclosure Act, so I'll just comment on that. it's absolutely the case that whistleblowers need support and need protection, and there are some gaps in the current regime, and the bill proposes a model that would address some of those gaps. At the same time, it's important to bear in mind that the PID Act itself is an overly complex, overly prescriptive regime, in my view, and that if the legislation itself is not simplified, then the Whistleblower Protection Authority will not go as far as it might be expected to go in actually assisting disclosures and in assisting agencies to elevate the purpose of the regime over the processes that are currently laid down in the legislation.
Thank you. Any other opening statements before we proceed to questions?
Chair, if I could make a brief opening statement on behalf of ASIC.
Absolutely.
Great, thank you. And ASIC didn't make a submission to the inquiry, but we're very grateful for the opportunity to appear today and stand ready to assist the committee with its work. Whistleblowers play an important role in uncovering misconduct. ASIC very much values the information we receive from whistleblowers. It helps expose misconduct that might otherwise go undetected for long periods of time and cause serious harm to consumers and to investors. We acknowledge that whistleblowers can find themselves in difficult and stressful circumstances, which often involve putting their careers at risk. And it's important, therefore, that Australia has strong and effective laws to protect whistleblowers. The Corporations Act provides two types of protection for whistleblowers. The first is a prohibition on whistleblower victimisation, and the second is a breach of confidentiality in relation to the whistleblower's identity. ASIC is empowered to investigate and take enforcement action in response to contraventions of those prohibitions. Civil remedies are also available to a whistleblower who has been victimised or had their confidentiality breached. For a whistleblower to receive protections under the Corporations Act, the disclosure must be made to ASIC, APRA, the AFP or a legal practitioner. Where the disclosure does not relate to conduct within ASIC's remit, ASIC may refer the matter to another Commonwealth, state or territory agency. We may also ask the whistleblower to raise their concerns directly with the relevant authorities, and we stand ready to answer the committee's questions. Thank you.
Thank you very much.
Thank you, Chair. I just have an opening statement too. Yep. Brief. Thank you. Thank you for the invitation to appear before the committee. We welcome the opportunity to provide insights from the New South Wales Ombudsman's experience oversighting the state's Public Interest Disclosures Act and the operation of our whistleblower support function. As a New South Wales Independent Integrity Agency, we don't comment on the policy merits of the Whistleblower Protection Authority Bill, but our submission provides context around the New South Wales Ombudsman's statutory oversight responsibilities under the New South Wales PID Act. At its broadest, this includes promoting a speak-up culture across the New South Wales state, local government and university sectors. Whilst this involves supporting sector-wide capability, it also includes supporting individual public officials navigate the process of making a public interest disclosure. A large part of our whistleblower support work is talking through the PID process, providing guidance on how to make an effective disclosure and ways to protect themselves from risks due to making the disclosure. However, we are evolving the type of support we provide. For instance, we are commencing 2 externally operated pilot programs, one providing dedicated wellbeing support and another providing legal advice that will supplement the work and support we currently provide. A whistleblower support function is intended to complement, not replace, the duty of an agency to support whistleblowers. In that context, we see the function as enhancing our role in protecting the integrity of the state's whistleblower framework. Chris Banks and I are happy to answer any questions you may have on the New South Wales Ombudsman's role oversighting the New South Wales Public Interest Disclosures Act.
Thank you, Mr Clayton. We will now proceed to questions, and I'll start with Senator Pocock.
Thank you, Chair. Thank you all very much for your time today. I've got one question which I'm keen to hear from everyone on, if that's all right. I might start with the Commonwealth Ombudsman. What challenges do you face in receiving whistleblower disclosures? especially when whistleblowers need ongoing support?
So the greatest challenge we face is that, as Philip Moss identified in 2016, in order to proactively fulfil our functions under the legislation, we need to be resourced to do that. And as far as I can determine, we've actually never received any resourcing for our functions under the PID regime. So we do what we can. There is more that we could do. We do have powers to do more, but it's a challenge of being able to find the resources to do all those different things.
Thank you. Maybe to the NAC, Mr. Reid.
At this point, with the small number of matters that have been brought through as referrals, we haven't experienced any particular issues at this point in time. We will treat all of the referrals, be they voluntary or mandatory, in a very similar way through our referral and assessment process, and then deciding which matters we may investigate at a later point. We'll put more resources in, and when we get to the point of investigations, particularly where we might end up in hearings, we have witness liaison officer, well, policies, but also officers to deal or try and provide support to witnesses that will appear in our hearings.
Do you know how many whistleblowers have come forward to the NAC in your existence?
So what I said in my opening address, was that we've only had 4 mandatory referrals from PID officers. So that's a requirement if there's a corruption issue which is perceived to be serious or systemic, it has to be referred to us. So there's only been 4 referrals that way. The voluntary referrals that come through are not identified as PIDs. They're just people that are wanting to make referrals about corruption issues to the Commission, and then we'll assess each of those on their merits.
And so if someone who's currently employed in the public service sends through a referral to what they think is corruption, you're not treating that as a disclosure under the PID Act, and you're not providing any support to them as a potential whistleblower?
Well, they themselves have not identified it as a PID, and so we deal with them as we would deal with any referrer, which is to ensure that we maintain confidentiality over the material. We get voluntary referrals from agencies as well as mandatory referrals, and so our processes are, at this point, I think, pretty sound in terms of dealing with those people that are making referrals to us.
And could you put a number on them? How many?
Well, we've got 5,400 referrals since we began on the 1st of July 2023.
Are you able to sort them for sort of APS?
We don't separate them. I mean, the mandatory referrers, we're obviously aware of where they've come from. The voluntary people may tell us where they've come from, but they may not, and it will depend on whether we need further information in terms of our assessment as to whether we go back and get in contact with them and ask for further details. Okay. But confidentiality and maintaining a strong policy of ensuring that the information is contained within the organisation is our approach to dealing with these sorts of issues.
New South Wales Ombudsman?
Yeah, thanks. So the New South Wales PID Act commenced in October 2023. So we reported on the first 9 months up to 30 June 2024. And there was, on that time, across the agencies captured by the PID Act, there was about 1,300 voluntary public interest disclosures made, and around 350 of those were made to integrity agencies, which are defined broadly within the PID Act. Most of the PID makers chose to not be anonymous, so around 30% of of individuals making public interest disclosures, so about 30% decided to be anonymous through that process. The whistleblower support function that we've got really tries to bring forward the support to people that are looking to make disclosures in a way that better informs them about the process that they might be about to expect when they do choose, if they choose to make a disclosure. But that's also available to people that have made disclosures already and are seeking support or advice in the middle of the process. And to date, so the whistleblower support function officially commenced in our organisation in November last year, and to date we've had about 65 people come to us in an independent way to seek support.
Thank you. And then just finally to ASIC.
Thanks, Senator. I think from ASIC's perspective, I think the most significant challenge is perhaps a gap between the whistleblowers' expectations or understanding of ASIC's role and what ASIC's role is, as in our role is to administer the legislative regime as enacted. We obviously seek to support whistleblowers to the extent we can, but there are significant limitations to the extent of that support. Our primary role is to assess those reports and make a decision in relation to the appropriate regulatory or enforcement response and whether we're going to enforce the law. Whistleblowers will often want legal advice from us, and our role is not to provide that legal advice. But we do, within the other expectation gap is I think we have to be necessarily selective in the cases that we pursue, given the resources available to ASIC and the breadth of our remit. We do nevertheless seek to provide limited support. So on occasions we have procured legal advice for a whistleblower, limited legal advice. We've also recently engaged a specialist whistleblower liaison officer with clinical skills. Many of the whistleblowers we're dealing with are under enormous stress. Sometimes they are in distress. So engaging with them in those circumstances can be challenging. But I just might see if my colleague from ASIC has anything to add.
Thanks. I'd just add, Senator, that we generally receive whistleblower disclosures through our website. I think in our last financial year we received about 700 whistleblower disclosures. Under the Corporations Act, there are certain people who can report to ASIC and by the nature of their position will be eligible for the whistleblower protections. Not all of those disclosures, not all of those reports to ASIC, the person is claiming whistleblower status or suggesting to us that the whistleblower protections are important to them, but generally it's about 700 of about 10,000 reports of misconduct that we receive each year.
Thank you, Chair.
Thank you. I need to share the call and I'll go to the Deputy Chair, Senator Chandler.
Thank you very much, Chair, and thank you all for attending today. Just one question that I suspect everyone will have some sort of a view on as it's relevant to your respective organisations. I'm keen to understand exactly how the authority that has been proposed in this bill differs from your existing whistleblower protection mechanisms. And I guess an open question, do you think that existing agencies could be resourced to perform these roles instead of creating a new body? might start with the NAC, if that's all right. Mr. Reid.
Let me just consider this for a moment, if you don't mind. In terms of our, what I've described in my opening address in terms of the protections under the NAC Act for whistleblowers, they exist at the moment. A new authority may assist in providing potential disclosures who may be uncertain about correct reporting pathway and available protections, and give them some further assistance. In the end, it will be, if it's established, the NAC and the authority having to work together about how to manage the interplay that is going to occur in terms of dealing with whistleblowers that come through our system or come potentially via the authority. And in my mind, it's probably pretty much the same as when we first arrived as the NAC, with a large number of other integrity agencies already in existence within the Commonwealth, that we ended up having to work with those authorities. They're defined under our Act, those integrity authorities. And for some of them, we've ended up with regular meetings. Others, we've ended up with MOUs as a way of managing that interplay. And I'm not sure that we would, I'm sure that we would do similar things were this authority to emerge.
Is there an argument, sorry, I do want to hear from other panellists, but is there an argument that that interplay needs to be codified in a more formal way than just having an MOU or regularly meeting, or, each organisation meeting with each other? Is that something that the Parliament would be better off looking at legislating or at least regulating?
Yeah, look, I think it will ultimately depend on the provisions, and if this bill passes as it is, then there will be certain elements of it that we would need to be clear with the authority about.
But that's not currently clear with the draft bill.
No.
Yeah. Mr. Anderson?
The bill proposes an authority that would have a number of functions that would overlap with or duplicate existing functions of my agency. So from that point of view, yes, we can continue to perform those functions, and additional resourcing would certainly assist us to do that without needing to have a new authority being created. There are some things that are proposed for the new authority, though, that we do not and would not do, and I've expressed concerns about the potential for a perception of a conflict of interest in that if an agency is, for example, such as the authority, investigating agencies who are handling PIDs, is also supporting and giving advice to the whistleblowers, there might come a point where if the different parts of the agency reach different views, the disclosure or whistleblower might feel that they don't understand why they're being supported and encouraged, but then they're not necessarily being agreed with by another part of the organisation. So I think that's a challenge, and I do think that there's a question as to whether some forms of support for whistleblowers are best procured or provided by a separate body. They could be funded through government, but nonetheless provided through a community legal centre that has expertise in these areas, for example. So I think that's something that we would not do, and I think is going to be challenging if a whistleblower protection authority was created. There's also, I guess, a question about, in the bill, it's not clear to us, and we said this in our submission, that while disclosures would be able to make a disclosure to the authority, it's not clear that they would in fact receive all the protections that the PID Act actually provides. So that would need to be something that would be addressed, whereas of course if a disclosure is made to us, then the whistleblower is fully protected.
Any of the other panellists want to contribute on that question?
Thank you. Just a few additional thoughts, very much along the same lines as the Ombudsman, that we do definitely see real benefit in terms of greater clarity in relation to the interactions between the proposed authority and the Commission, and just in that tension as raised by ASIC in terms of when we investigate matters, we don't do that on behalf of referrers, and we see within the bill that There will be a monitoring function in relation to the Commission, and also the ability for the authority to seek information from us as well. And you can see there potentially a tension arising in relation to our respective roles, and it's unclear at the moment how that would be worked through.
Great. I might leave it there, Chair. Thank you.
Thank you. I'll go to Senator Polley.
Thank you, Chair. It's a complicated bill in terms of from an oversight, but I was just wanting some advice from the Ombudsman about existing framework and the responsibility of your office to oversee the Public Interest Disclosure Act and how that integration would work.
So we have the function of overseeing the way in which the PID Act operates, other than for intelligence agencies. That's the Inspector General of Intelligence and Security who performs that function. The challenge for us is resourcing, as I've said. So we receive now reports of PIDs, we receive advice of allocation decisions on PIDs. We could do more to investigate what agencies are doing. We can make recommendations to agencies that matters should be reinvestigated or should be investigated in the first place. We can make recommendations about actions agencies should take with respect to disclosures, as well as with respect to other staff in the agency. But the challenge for us has been actually doing much with that function with our current resourcing, because we have focused on handling directly the disclosures we receive or complaints about disclosures. So one of the challenges with the bill is that it would give similar or duplicative functions to the authority. It would be able to also engage with the agencies and engage with us about matters we were looking at, or separately about matters that they wish to look at. And so there is the potential for multiple handling on the same issues, which may not be in the interests of the disclosures or indeed of other parties. It's better to have overlaps than to have gaps, I think, and these things can be addressed in a range of ways through MOUs and protocols and things like that. But it would be something that would need to be considered very early on if an authority was created on this model.
So to that extent, a lot of what this new authority wants to be able to do, you could do with greater resourcing.
Yes,
Is that correct understanding?
That's correct, Senator. But there are things that the authority would do that we would not do. And I've pointed already to that question of some forms of support for whistleblowers, I think, are better provided by another entity again, not by someone who's actually doing investigations and doing oversight in that way.
So currently your role when it comes down to whistleblowers who are experiencing reprisal, what's your role there? So
we have the ability to examine a complaint by a disclosure who is alleging that they've suffered reprisal. We have the ability to look at a report by an agency in terms of how they have managed potential reprisal risks. We've commented publicly to the effect that we don't think agencies are very good at actively managing risks of reprisal. They will prepare a reprisal risk assessment at the start of consideration of a public interest disclosure, but not necessarily have regard to it as the investigation progresses. We provide education and we do provide assistance for disclosures as well, but the education piece, we've been targeting authorised officers in agencies, people who are authorised to receive PIDs and to consider PIDs. I think that there's a much greater amount of education that would be of assistance to the public sector, so that generally people have more of an understanding of the value of PIDs. That PIDs actually should be seen as being intelligence that someone has concerns, and you should actually be thinking, why is it that this person has concerns, as opposed to getting bogged down in this overly legalistic, overly prescriptive process which tends to drive the purpose of the regime out of people's minds.
If I can ask a question then of NAC, what are some of the obligations and issues that might arise in the case of public officials that may differ from the obligations of private sector employees, from your perspective?
So
Sorry, I'm not quite sure that I fully understand. So you're trying to say for a public... Sorry?
Sorry, go ahead.
No. I'm just trying to clarify the question that you're asking.
So obligations and issues that might arise, can they be different from the public officials as opposed to the obligations that would differ from private sector employees? Do you have a view on, are there different issues? Are there different obligations from NAC's point of view?
If I'm understanding the question, Senator, I don't think so. I think the concerns of whistleblowers are probably the same in the private sector and in the public sector in terms of how they go about making that report, being concerned about potential reprisal actions, being educated about what their protections are available to them. So I can't see a distinction between the two.
Okay, thank you. And from ASIC, just wondered how many whistleblowers have come through ASIC over the last, say, 5 years?
Greg, did you want to respond to that?
Sure. Senator, I mentioned a bit earlier that it's around 700 reports from whistleblowers each year over the past sort of 5 years. There were some significant reforms to the Corporations Act whistleblower protections that commenced on 1 July 2019, and since that time, it's been around sort of 600 to 700 per year. As I mentioned earlier, the definition of whistleblower in the Corporations Act means that certain people who report to us will, by their position, be eligible for those protections. Those protections may not always be relevant for those people, but they do attract them when they report misconduct to ASIC. In terms of our kind of process, we do have information available to whistleblowers about the legal protections, about how the regime works, available to them. We give that to them when they lodge reports with us. We also provide them with information and sort of ask a series of questions when they do come to us to try and both get an understanding of any risk they may face about a potential breach of the whistleblower protections, so such as suffering detriment or a breach of their confidentiality, to try and understand that whether that aspect is also relevant to them or whether or not they are just lodging a breach of the law, alleged breach of the law with us.
So with those 700 whistleblowers that have come through ASIC, do you see any different issues that arise between corporate whistleblowers versus the public sector whistleblowers? And if so, what are the issues?
Senator, we will generally receive reports about alleged corporate misconduct. We won't see reports about that might also be relevant in relation to misconduct occurring in the private sector. In the public sector. It doesn't mean that we don't receive them, but we generally receive reports about corporate misconduct. The largest proportion of whistleblower disclosures to ASIC probably have a nature of alleged corporate governance misconduct. That's about sort of 60 or so percent. About 20% relates to our financial services jurisdiction. So these would be whistleblowers raising concerns about the operations of financial services licensees. It is something that we are aware of, and it's something that we've engaged with other public sector departments and agencies about, where there may be a crossover between alleged misconduct that would occur that could be relevant to the Corporations Act and it could also be relevant to the PID Act. And we do have the ability to sort of engage with other agencies if there is misconduct that might cross both regimes. We have engaged with some companies out there that have that may also have to comply with PID Act regimes because they are contracted to the government, for example. And we have certainly found that engagement to be quite difficult because it is the two regimes working together raises some complexity.
So if those 60% of whistleblowers cases, what sectors make up that 60%? If 20% is finance, where's the other 60% made from?
That's how we would generally characterise the concerns that could be reported to ASIC, given we have a corporate governance, corporate law, regulatory responsibility. We also have a financial services regulatory responsibility. So within those reports that have a sort of a corporate governance, corporate law aspect, they could be raising concerns about solvency, they could be raising concerns about directors' duties, they could be raising concerns about disputes happening within the conduct or potentially other corporate misconduct such as fraud. So there's sort of a variety of issues that might be reported in that proportion.
So there's no sector that...
Sorry, I'm going to have to share the call, Senator Polly.
Thank you.
Senator Lambie.
Yeah, just for the Ombudsman, you've been in for 3 years now. How many whistleblower complaints have you had in under your time?
The exact numbers of the complaints sort of come to us would be in our annual reports. I don't have the data here, but it would be over the last 3 years, maybe about between 100 and 150.
Mm-hmm. And how many of those have you been able to resolve, or how many have you passed off?
We look at all the complaints. We will make a decision about which of those require sort of more formal investigation. There would be a smaller number of those that result in specific comments or suggestions, or might even get to a recommendation under the Ombudsman Act. Again, I think these figures would be in annual reports.
Yeah, but I'm asking, I'm just trying to work out, I guess the nicest way to say is I've dealt with you guys before, and a lot of my complaints in the past have not gone anywhere. I'll be openly honest with you. And that has been because of staffing issues. We've been over this before. So how many investigators do you have on your team?
At the moment, we have a team of 8 FTE, and one and a half of those are dedicated to looking at complaints and investigations.
So you have 1.5. You have 1.5 people to look at all those complaints and investigate at the same time. Is that what you're telling me?
Yes, that's what I'm telling you, Senator.
No wonder you can't get your job done. How many of those have been defence complaints in the last 3 years?
Are you meaning defence PIDs or defence complaints? And do we have other functions?
Both.
I have 20 different statutory functions. Defence Force Ombudsman is not the same as the PID function. So we've dealt with 5,000 complaints about abuse in the Defence Force. If you want to talk about those, or do you want to talk about PIDs about defence? I'm not sure about the question.
I'll speak about both of them. We've had 5,000 complaints since on abuse.
On abuse suffered or alleged to have been suffered by people who are serving in the Defence Forces.
Okay, that's over a period of time though, is it?
That's over a period since 2017.
Okay, and where are those complaints at now? I mean, we've just gone through a Royal Commission. Have many of those people been paid compensation, or what are you doing with all that?
So $134 million has been paid out in reparations to those people on our recommendations. Senator.
Okay, this is the defence abuse stuff.
Yes, so we're getting away
from 2015, and we're still paying those people out.
Well, we've completed...
This has come from the DLA Piper stuff, and from 2013, 2016, we've done a Senate inquiry on defence abuse. Are you still sorting that stuff out after 9 years?
We received 5,000 fresh complaints of abuse that people had suffered that had not been made to the Defence Abuse Response Task Force, the DLA Piper process or anything like that.
Yeah, that's because that's now shut down, is that correct?
Yes.
Yep. Okay, so... How many of these complaints in the last 3 years, whether it's defence or anything else, have you sent to the NAC since it started?
I'd have to take that on notice, Senator. It's a very small number that we've sent on to the NAC, but we have referred some matters to the NAC.
And why is that when you've got 1.5 people that can investigate and do that job? You'd have to be extremely overwhelmed. Why are people sitting and waiting?
So I said that the PID scheme is a decentralised scheme by design. So the agencies have the primary obligation for dealing with allegations about issues within their agency. The matters that we look at and investigate directly are generally matters that an agency is not able to deal with. So, for example, allegations about very senior people in the organisation. As a general rule, though, if a disclosure comes to us with a concern about a particular agency, we will refer that back to the agency and ask them to investigate it.
Oh, so I come to you and I have a complaint about the agency I'm with. I then go to help for you, and then you refer me back to the agency.
That's the scheme that Parliament enacted, Senator.
Wow, how much harm is that doing those individuals? What is that costing us, the taxpayer, by doing it that way?
Senator, the fact that someone has a concern about conduct in the agency that they work in does not mean that that agency is completely unable to investigate that concern.
What happens when they've already been to that agency? So when they've already been and gone through that and then come to you, do you then send them back to the agency? When that complaint's already been looked at the agency, how many of those situations are we looking at?
Senator, if someone comes to us with a complaint about how their PID has been investigated or handled by the agency, then we will look at that ourselves.
Okay. And how many of these... Oh, actually, that doesn't matter. How should Australia balance the benefits of a centralised whistleblower authority with risks of overlapping functions, potential confusion and inconsistent advice from existing oversight bodies?
So you're saying the benefits against the challenges?
Mm-hmm.
Senator, as I said in my opening statement, there are certainly issues with the PID regime, there are gaps in it, and support and protection for whistleblowers are very important. The Whistleblower Protection Authority, as proposed in this bill, won't actually address some of those issues of protections that are required for whistleblowers. For example, the time from which the protections under the PID regime actually commence. It's my view, and we've suggested this publicly, that those protections should commence as soon as an internal disclosure is made, not as soon as it's actually accepted as a PID by an authorised officer. So there are things that could be reformed in the legislation that would provide additional support for whistleblowers that are not in this bill.
Okay, thank you. I have no further questions.
Thank you. Senator Shoebridge.
Thanks very much, Chair. Just to the New South Wales Ombudsman, and thanks very much for your assistance. Having established this new whistleblower function, I think the legislation passed recently. What is your staffing of that function now? And are you fully staffed? Are you ramping up? What's the current headcount?
Yeah, thanks, Senator, for the question. So, by way of context, we've got at an organisational level, the New South Wales Ombudsman has around 260 staff. That's to cover the broad range of functions, so traditional complaint ombudsman functions of complaint handling. In terms of our oversight over the public interest disclosures framework, we have around 25 staff. That includes staff that provides advice to agencies. It also provides our engagement with Aboriginal and Torres Strait Islander communities and agencies, as well as our auditing and monitoring function as well. The subset of that is dedicated to our whistleblower support team, which is led by Chris Banks, is around 5 staff. That is probably that is what has been funded within our budget envelope. Given that the PID Act is still relatively new, there's probably some maturity around what is the optimal number of staff we need. But currently, we're operating with around 25 staff that are supporting the broad range of PID oversight functions.
Oh, thanks very much, Ms. Clayton. I might then go to the Commonwealth Ombudsman. I might have misheard your evidence, so that you gave to Senator Lambie, but can you identify the number of staff handling PID complaints?
Senator, I'd said that we have a team of 8, and I have, at this minute, 1.5 of those staff focused on investigations and complaints.
All right. Now, the Commonwealth is a bigger entity than New South Wales. We have 25 in New South Wales, 5 dedicated just to helping whistleblowers. Is there anyone dedicated to just that whistleblower support role in the Ombudsman's Commonwealth?
I would say we probably have a staff member who is there to answer the inquiries that we receive from disclosures and potential disclosures looking for some assistance.
And did you say there were 1.5 staff for investigations for PID Act referrals? 1.5?
So that's where people have made a disclosure to their agency and have concerns about how it's being handled. They can make a complaint to us and we will investigate those complaints. Or on those occasions where we receive a whistleblower report and we have concerns about sending that to an agency for investigation and feel that we need to investigate it ourselves. So we take on a small number of those where we need to, and that's what those staff would be doing.
The Commonwealth budget is close to $1 trillion of spending a year, and there's 1.5 staff associated with investigating whistleblower complaints in the one agency that's been clearly identified with it. Is that it, 1.5 staff?
I mean, that can fluctuate depending on what we've got on. We have a number of functions under the PID Act, so it can change a little bit.
It's one of the concerns that's been raised by the Ombudsman and other bodies is this concern about duplication. If we're duplicating the work of 1.5 staff, that's not what I'd call a major institutional problem, is it?
Senator, I mean, the issues about duplication, we haven't said that that's a fundamental concern. We've just said it would need to be addressed.
Well, you couldn't. You've only got 1.5 staff doing it.
So, Senator, the
Embarrassing thing to say.
the evidence that Ms Miragai gave was that number will fluctuate from time to time, depending upon the volume of matters that are coming in as well.
People want to know who we're voting for.
Well, I'd like they do, but like, who are the left pushing in? You want to do it?
I think there's somebody with a variety of undisclosed chatter.
I've got it because what's the name, Senator?
You're not on mute.
I'm finding it
Senator Ollie.
interesting, but not critical.
Sorry, Senator Rich, go for it.
I think people do want to know who they're voting for. Well said. So can I just, in terms of, you say the number fluctuates, it could double or triple. It would still only get to 4.5. What's been the highest that you'd know for that number to be?
Yeah, look, you're right, Senator. It's not going to get to being the 25 that New South Wales has, and New South Wales Ombudsman had a very significant increase in its funding in the last financial year or so. I think they got their funding almost doubled. I think that's a great demonstration of the treatment of integrity agencies in different regimes.
What's the number? You said it fluctuates. What's the biggest it's ever been?
Oh, in the 3 years that I've been in the Ombudsman, it probably wouldn't have been more than 4 or 5 at the most, Senator.
Okay. And just to be clear, the Commonwealth is bigger than New South Wales, isn't it?
Well, the Commonwealth Ombudsman has about the same budget as the New South Wales Ombudsman, in my understanding, because they've had their budget significantly increased very recently.
How do you think that the hundreds of thousands of people who work for the Commonwealth public sector would feel if they found that the principal agency identified with investigating their public interest disclosure matters had 1.5 staff attached to that function? Do you think that would sort of undermine confidence in it?
So, firstly, Senator, we're not the principal agency responsible for investigating PIDs. Actually, it's a decentralised system. The policy is that agencies have the primary obligation. That's the same in New South Wales.
The only identified.
So that's one point I'd make. The second point, though, is that when Philip Moss reviewed the operation of the PID regime back in 2016, he said that if you want to have effective oversight, you need to properly resource it.
Oh, Ombudsman, I'm not criticising you for the funds you're dealing with the cloth you've been cut by the government, and I understand that there are enormous other resources, but you're there sort of carrying the responsibility for the agency, and it's woefully inadequate funding, isn't it, that sees you with 1.5 staff members doing this critical job?
I would certainly welcome additional resourcing to carry out my functions under the PID regime, Senator.
To the NAC, did you say you'd had some 5,400 referrals, corruption referrals?
5,400 over the last 2 years. Yes, that's how many have come through the door. We report on that on a regular basis.
And only 4 had come as formal disclosures under the PID Act, is that right?
Where they were mandatory referrals from agencies where a PID officer had identified that there was a corruption issue that could potentially be serious or systemic. There's only been 4.
And have you identified in those 4 that you had 4 whistleblowers? Is that how you've identified 4 whistleblowers?
I don't have any further details about those 4. It's just 4 is the number.
All right. Well, you were asked about how many whistleblowers had been identified by the NAC, and the answer you gave was only 4 have come through that process.
That's right.
So I understood you to say, well, there are 4 cases where there are whistleblowers.
Look, I'd have to...
Had I misunderstood you? Because you gave
No.
in relation to that question.
Yeah, you may not have misunderstood me. I just said that there were only 4 that we can identify that had come from agencies, from PID officers in agencies. I mean, there's been over 220 mandatory referral from agencies that could be serious or systemic corruption, that could be the equivalent of a mandatory referral of, you know, what might otherwise have been a PID to the organisation, but they've come as a mandatory referral from the agency about a corruption issue that could be serious or systemic, if that makes sense. So
well, you were asked how many whistleblowers has the NAC had referrals from, and the answer you gave was there are 4 matters that have come through the PID, and I therefore assume you've identified four matters involving whistleblowers. So I'm going to ask you, how many whistleblowers has the NAC identified having made referrals to it?
Well, I mean, the voluntary referrals that come through are potentially people that are blowing the whistle on something, but they're not identified under the PID Act. They just come through as a corruption referral to us. And so at this point, we're treating those matters that come through the door as being all allegations, or sorry, not allegations, corruption referrals that need to be assessed as to whether they fall under our jurisdiction.
So whether it's a whistleblower or not, whether it's a person who might have put their career on the line, be facing all those anxieties with an agency, that's not part of your initial assessment. You're not identifying people who may have those vulnerabilities. That's not what you do.
What we're identifying is what issues are they raising? Are they about a public official? Are they in relation to a corruption issue? And then we have to determine of those which might be serious or systemic. So it's quite a significant assessment process
You're looking at the issue, not the person.
Oh, well, I mean, clearly we are looking at the person. There's vulnerable people that come through the door. There's absolutely no question about that. And so we are trying to make an assessment about the matter they're bringing to us. Is it within our jurisdiction or not? And then what would we do if it is within the jurisdiction? Is it a matter that we would investigate ourselves? That would have to get to the serious or systemic threshold for an investigation. And there may be other matters that get referred back to agencies, or agencies already undertaking investigations on themselves.
Yep. But my questions are about what, if any, protections you're putting in place for vulnerable people who would identify themselves as whistleblowers, and most people on this committee and most of the public would identify as whistleblowers. Mm-hmm. And I think the evidence you gave earlier was that you have witness liaison officers. Is that right?
We do have witness liaison officers, and if people are particularly vulnerable, even if they're coming through the assessment process, we will engage the witness liaison officers to consider how we may deal with those individuals, how we might assist those individuals.
That's the same resource that you would apply to someone who's perhaps colloquially described as the target of your investigations, as somebody who is the whistleblower.
Well, but witnesses are not all targets. They're not all persons of interest. Witnesses potentially are people who may have information about a particular matter.
Perhaps if you just respond to my question, you are providing the same resources to persons of interests, or colloquially known as targets, in the form of witness liaison officers, as you're providing to the whistleblower, the potentially incredibly vulnerable whistleblower who came to your organisation in the first place. providing the same resources, aren't you?
Well, we're using the same processes to deal with people that come through, and there's, you know, these are corruption issues that we're trying to define whether they need to be investigated or not investigated, and we understand that the more that we work on a particular matter through a preliminary investigation or a full investigation, that we are dealing with quite vulnerable people at times that are not identifying as whistleblowers, they're identifying as people raising a corruption issue, and we will then ensure that the protections under our Act apply to those individuals where you know, it's an issue that is actually within our jurisdiction. But most of the matters that come to us are not within jurisdiction.
You see, I don't see anything distinct that the NAC has put in place to protect whistleblowers. And if I'm wrong in that, please feel free to answer on notice any distinct identified protections the NAC has put in place to protect whistleblowers.
Okay, we're happy to take that
question
on
on notice, Senator Shoebridge. I've got a follow-up question from Senator Lambie before we go to lunch.
Okay. I'm just wondering, have you had any corruption referrals to the NAC from Defence itself?
Yes, we've publicly, in answer to a question on notice, identified that we've had 120 referrals about Defence.
But not from Defence itself?
Oh no, we've had referrals, mandatory referrals from Defence. I'm not sure within that 120 how many are mandatory referrals.
And if I can just ask one more off that, please. How many Defence personnel, whistleblowers, have come forward? How many Defence contractors have come forward to blow the whistle on what's going on in that area? How many of them do you have? How many Defence cases do you have on your books that are looking at blowing the whistle right now?
Well, we've had 120
Anything to do with
matters referred
Defence?
to us, Senator.
How many?
So we've had 120 matters referred to us, but not all of those will necessarily end up being investigated. I mean, that's part of the assessment process we have to go through for every matter that comes as a referral to us.
And what's the average investigation time before you get to that point?
Well, the assessment time is 86% done in 90 days, but when it comes to preliminary investigations and other processes, and if we were to fully investigate, there's no, at this point, no average time frame that we could identify to you.
Okay, and Ms Dance, if you could just take a question on notice, please, is that your 1.5% person that is doing those cases, how many cases are right now sitting in front of that person on that desk? If you could just get that back to me, that number, that'd be great.
I appreciate that question.
Thank you.
On notice.
Appreciate that question on notice, Senator, and we'll now take a short suspension for lunch. Okay. Thank you very much. I first want to thank you for coming a little bit earlier than you were planning to. And I now welcome representatives from the Attorney-General's Department and Treasury. Thank you for taking time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanation of policies or factual questions about when and how policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appear? And I'm starting on the left.
Erin Emerson, Director of the Transparency Frameworks Branch in the Attorney-General's Department.
Good afternoon. Susan McCaig, Assistant Secretary, Attorney-General's Department.
Deepti Payton, Acting Assistant Secretary, Corporations Branch, Treasury.
Anne Robertson, Acting Director, Whistleblowing Review Unit at Treasury.
Thanks, Chair. Barton Hoyle, I'm a Director in Legal Policy Unit, Treasury's Law Division.
Thank you very much. Do either of you have an opening statement before we proceed to questions?
No, thank you.
Okay, happy to proceed directly to questions. Deputy Chair.
Wonderful. One of the issues that we've sort of canvassed throughout the morning with this inquiry is this idea of the overlap of the Whistleblower Protection Authority's functions and those of existing bodies. We had most of them in at the last session answering some questions for us. I was wondering whether Attorney-General's Department in particular had any views on how that whether that overlap is sufficiently managed in the existing bill, because I think we've had some views from the previous witnesses that it's not. And so, you know, how do we understand what that overlap looks like? What more work would need to be done to be able to rectify any overlap? And then perhaps if Treasury had any view on any of the costs impact of that overlap as well, that might be useful information for the committee to have.
Thank you, Senator. I think as other government representatives have identified, there is a degree of overlap with functions, particularly, and I'll speak to the public sector whistleblower framework with respect to the functions of the Ombudsman. So I think it would be very important that there was clarity as to how the proposed Whistleblower Protection Authority would interrelate with those functions of the Ombudsman.
And that clarity is not currently in the bill, is it?
It's not currently in the bill. I also think that insofar as the bill would seek to cover private sector frameworks, public sector frameworks and NGO frameworks, then that would be a significant extension of the frameworks that currently apply. I think the Attorney-General's submission makes clear that government has committed to stage reform of the PID Act. In that sense, stage one is already complete. It was completed in 2023 to make immediate improvements to support the establishment of the NAC. Government has committed to a second stage of reform. Those reforms are currently under consideration. I think separately, my Treasury colleagues will speak to the statutory review of the Corporations Act and Tax Administration Act frameworks that they are also responsible for. So I think it would be premature in that context, and in the absence of findings from the Treasury review, and also having regard to government's commitment to progress stage two reforms, to proceed with the bill as currently framed.
To add to Ms McKay's testimony, we do have a review underway at present in relation to, in particular, whether the amendments made to the corporate and tax whistleblowing regimes in 2019 are hitting the mark, whether there are any gaps. We expect to hear some of the feedback in the context of that review that has been submitted to this committee, and we're also alive to other options to bridge some of those gaps and so forth as identified. I can't speak to the costs directly. I understand that this proposal has been costed by the PBO. Perhaps if I can have a few moments to pull that up, I'm happy to speak to the numbers a little later on.
Does the Whistleblower Protection Authority, as proposed under this bill, ensure consistency in legal interpretation across different whistleblower frameworks?
I think the proposal is to set up a standalone Whistleblower Protection Authority. The question of alignment between legal frameworks is already something that government is alive to, and where appropriate, we would give consideration to aligning protections. In fact, there was some movement in that direction as part of the 2023 reforms. I think I would perhaps add that Moss, as part of his 2016 review of the PID framework, gave consideration to whether or not there would be value in combining the public sector and private sector frameworks. He felt that there were different rationales and contexts that both frameworks existed in, and he thought that it would be not something that was, he said it would be ill-adapted to private sector whistleblowing as the accountability processes and mechanisms are different. So he wasn't persuaded by the benefits of seeking to bring both frameworks together.
I'm happy to hand the call on, Chair. If I've got other questions at the end, we can come back.
Yeah, absolutely. Thank you. Senator Pocock.
Great, thank you. Thank you very much for your timing today. I might start with AGD, if that's all right. From your perspective, what benefits could a single specialist body bring in terms of consistent application and enforcement of whistleblower protections across the public sector?
I think as part of government's commitment to stage 2 reform, what the Attorney General's Department is focused on is looking at improvements to the PID Act, which would improve, reduce complexity and improve its accessibility. I understand that the Ombudsman spoke to the issues of complexity in his evidence to the committee. I think the question of an independent body and how that could support the existing protections doesn't necessitate a standalone Whistleblower Protection Authority as currently proposed, but I appreciate the issues which I think the model seeks to address.
Mm-hmm. And so when it comes to whistleblower protections, is AGD basically just doing what the government has said, or are you working on options that you think are best practice to present to them? How does that policy sort of stuff
as
work?
As part of the stage 2 reforms, the Attorney General's Department undertook a public consultation process at the end of 2023. As part of that process, we received submissions from 56 entities, individuals, organisations, government departments. There were 24 questions posed around 3 topics. And so the issues canvassed as part of those consultations are wide-ranging, and as part of our role in analysing and considering implications for reform, that full suite of submissions will be given consideration.
Thank you. And of those 56 submissions from different entities, how many of them referenced the idea of a Whistleblower Protection Authority?
I'd have to take precise statistics on notice, Senator.
Okay, thank you. Do you think a Whistleblower Protection Authority could strengthen coordination between existing oversight agencies and improve the timeliness of responses to whistleblower concerns? And one of the things we've heard is it's kind of all these silos dealing with whistleblowers basically unresourced. You know, the most resourced he's the Commonwealth Ombudsman with 1.5 FTE to deal with whistleblowers. Do you think having this kind of one-stop shop that can actually help them would be beneficial?
I think government would always consider carefully a requirement to set up a new standalone body, particularly where there are existing bodies with relevant functions. And so I think the question of duplication and efficiency is something that would need to be considered, and I think there would need to be clear consideration given to the interactions and handoffs between agencies in the system.
Mm-hmm. And as part of the second tranche of the PID Act reforms, has the department considered whether such an authority should be a standalone body or part of an existing institution?
Broadly speaking, they were questions which were asked about as part of the public consultation paper, and so the department has received submissions in relation to advocating for a whistleblower protection authority model as we understand it, but there have also been submissions which have taken a contrary view, for example, and would seek to leverage existing frameworks or propose perhaps even different models again.
You mentioned the submissions earlier, but I'm interested, has the department, based on that feedback, actually then looked at, given I imagine a number of people did recommend some sort of whistleblower protection authority, have you looked at whether that should be standalone or should be added to, say, the Commonwealth Ombudsman? Have you undertaken that work?
We've undertaken the work to give consideration to all the different proposals that were raised through that consultation process. We've obviously given consideration to this bill as part of this process as well.
Okay, have you provided advice to government on that?
It's not something that I can provide a comment on, Senator, as to whether or not advice has been provided to government.
I thought you couldn't talk about what advice has been provided.
That's correct.
To government. You can tell us whether or not you've provided advice on that thing.
Where government's made a commitment to progress the
No, I understand that. We've heard it all from the AG, and I'm just interested, has the department worked up proposals on, when it comes to different models of a whistleblower protection authority or some sort of body, and provided that to government for them to look at, or are you still working through it?
I can say, we will provide advice to government on the suite of issues which are raised, and then the nature and timing of any decision is a matter for government.
No, I understand that. I'm asking, have you provided advice? I'm not trying to catch you out here. Like you work for the Australian people, and a big part of the thing I've been hearing is about the need for frank and fearless advice. I'm just asking, have you provided that advice to government yet?
We are in the process of developing proposals for government's consideration. I'm not in a position to comment on the nature of advice which may have been provided to government.
Maybe you can just take that on notice and check whether, I don't know how it works, the minister wants to claim PII, or it just seems to me like this is it's a really frustrating area where I feel like the Senate needs to apply the standing orders and not just.
We need to make the minister come in. If our own people can't do it, we start using that tool that we have.
Yeah, and I'm not trying to.
I think that
it's just
the official can take on those.
Sure.
She can give you,
sure.
And then
Thank you.
there's definitely opportunities to question the relevant minister estimates too.
Right, thank you. Can I ask some questions of Treasury?
Yeah, absolutely.
In your early scoping for the statutory review of the Corporations Act and the Taxation Administration Act protections, how often does the need for a whistleblower protection authority come up?
We haven't yet commenced formal stakeholder consultations. We've spoken to a few entities that have come to us to give us ideas about what that scope should include, and my understanding is that the notion of an overarching authority has come up in those conversations.
And what about in those conversations? Has that come up?
I beg your pardon?
In those initial conversations, has the idea of a whistleblower protection authority been raised?
I understand it has been raised by stakeholders, yes.
And will your review specifically consider whether a whistleblower protection authority should be established, given it's been raised in initial sort of scoping conversations?
My anticipation is that our review will progress along sort of a fairly well-established pathway for Treasury, which is exploring what the issues are initially and then having a serious think about policy proposals and shaping them for implementation and exposure. In that context, we are conscious of a lot of the submissions that have been made to this inquiry and others in relation to problems about the overlap as well as the delays and so forth. The no wrong door can sometimes mean no right door, those sorts of ideas and so forth. So we are looking to ventilate some of those issues through the consultation process, yes.
Mm-hmm. Is there a reason why I would not specifically consider the arguments in favour of a whistleblower protection authority?
Beg your pardon?
Is there any reason why it wouldn't specifically look at the arguments in favour of a... You said you were looking at sort of policy proposals, and we've seen basically all the integrity organisations say that we need a whistleblower protection authority. The Senate 30 years ago decided that we needed a whistleblower protection authority. I'm just interested in why you wouldn't look at that as one of the potential solutions.
I'm not suggesting at this stage that we wouldn't look at it. I think that's a premature call for us to make. Initially, we'd be looking to get a full read on the issues and concerns that exist in the community about the current state of the law.
And what's the timeline for that process?
We've provided some initial advice about next steps for the review. We expect a consultation process to be centred around a paper, but that the timing of the release of any such paper would be a matter for government.
Okay, so once the government decides when they want the paper, what's the timeline from the paper?
To conclusion?
Yeah.
Our standard consultation parameters usually see us see us put the paper out for 4 to 6 weeks at a minimum, but we'd consider specific timelines beyond that at the moment when those decisions need to be made.
And then post 6 weeks, how long does it usually take to sort of synthesise that and come and provide the government with policy options?
It does depend on the scope of the feedback. I'd hate to speculate at this stage because it would depend on what we would get back, but typically in other similar processes we'd allow at least a couple of months.
Mm-hmm. Well, thank you. One of the concerns I keep hearing is about the lack of coordination between, say, corporate regulators, tax authorities, others. How could a whistleblower protection authority improve that coordination when handling whistleblower matters?
So if I can go back for a moment and talk about the system that exists at present, it's in effect a system of referrals, and that is going to create both advantages and disadvantages in context, and the onus is on the recipient of the disclosure in order to handle it in a way that sees it go to its rightful home for action. The question of whether an overarching authority would improve that coordination would depend on the way that the overarching authority was set up and the way that it relates to all of the existing bodies, and whether there are arrangements in place to make sure that the information travels speedily. There's also a possibility that the addition of another authority could create some confusion for stakeholders too. So very alive to that.
Yeah, how would that?
Explain that to us. So at the moment, we talk about no wrong door as being a policy aim in terms of there are many recipients of disclosures, and ASIC is the appropriate sort of recipient of disclosures in relation to corporate wrongdoing in this context. If there were another authority that sat beside or on top of ASIC, I can see there being circumstances where stakeholders might wonder what the nature of the engagement is between ASIC and the authority, whereas at the moment their queries are with ASIC directly in relation to corporate whistleblowing.
And so we've heard about the second tranche of the PID Act reform, which may or may not have been provided as advice to government, and now we've got a consultation process under Treasury. How are these sort of two separate processes working together or interacting?
So we work very closely with our AGD colleagues and concur with Ms McKay's testimony completely in that there are separate but related policy rationales that underpin the public interest disclosure regime as compared to the corporate regime. So we've always had regard to the way in which the reforms in relation to the PID Act are unfolding and look to make sure that we are basically importing what makes sense or being aware of what stakeholders are saying in that context. But we always run it through a lens of whether the specific paradigms or changes make sense in the corporate context.
Okay. I guess I'm just concerned that there's a siloing of how we can best address what is a huge issue, the lack of support for whistleblowers. And as a parliamentarian, I've been shocked by how many whistleblowers approach my office because they've just got no support, no avenues. And yeah, I guess I'm really concerned about. Clearly got a need, I think, for support across the private and public sector, and experts keep telling me that a whistleblower protection authority is a great way to do that, but it's probably not what I'm hearing from the government or the department at this stage. So maybe just a final question to Attorney General's Department. We heard earlier that the Commonwealth Ombudsman has 1.5 FTEs to support whistleblowers. Are you aware of any other Commonwealth funding or roles specifically to support whistleblowers?
Thank you for your question, Senator. Perhaps if I can go back in terms of advice to government, I can confirm we have provided advice to government, but generally in relation to stage 2 reforms. It's not a matter for me to go into the details of the nature of that advice to government. In relation to the question of funding for the Commonwealth Ombudsman, funding issues as a sort of as portfolio agency, the Attorney General's Department works with the Ombudsman to seek to bring forward funding proposals for consideration by government as part of stage 1 reforms. The Attorney General's Department assisted in the development of guidance and advice for the Ombudsman. I think I understand that as part of also the follow-up from the Royal Commission, there was some funding that went across to the Ombudsman generally for his statutory functions.
And so are you aware of any other Commonwealth money that goes to any agency involved in integrity, otherwise that's for supporting whistleblowers, or is it just the 1.5 FTE at the Ombudsman?
In terms of integrity frameworks, the PID Act is just sort of one pillar of the broader Commonwealth integrity framework. So I think in that sense, consideration would also have to be given to the establishment of the NAC, which is a very significant addition to the integrity landscape. And there are also, as we've heard, private sector whistleblowing functions within ASIC and other organisations.
Okay. I guess I'm hearing that there isn't. We heard from the NAC earlier, and they said that they do sometimes provide support, but they have no sort of dedicated support for whistleblowers. So I think you've kind of answered my question. Thank you. Thank you, Chair.
Thank you. I'll go to Senator Lambie next.
Thank you. I find it bizarre that nobody has put in psychological support, whether it's with ASIC or whether it's the Attorney General, to any of these whistleblowers. That is shameful in itself. Even the Royal Commission with veterans had a big support system set up. You've been in support for years. Have any of you ever fought for that or asked for that, whether it be a Liberal or Labor government? Or have you just been quiet? Okay. Stage 2 reforms. Are they at Cabinet? Your Stage 2 reforms on the Whistleblower Protection Authority, are they at Cabinet on the table? Because I just want to ask you that, because you've nearly had 2 years.
So I think you'll appreciate that they are processes that I'm not in a position...
I'm not asking you about it, I'm just saying, are they at Cabinet? Have you produced them to Cabinet? Have you sent them to Cabinet? I'm asking you that. Has the Attorney General's office sent that paperwork to Cabinet?
Senator...
I'm sure you're obliged to answer that question.
Yeah, can I...
Yeah, enough.
Jack, I've got the...
Thank you.
Just looking in the Guide to Committee Procedures and Practice, which is also referenced in Odge's page 667, on advice to government, it says, as with legal advice, the mere fact that information consists of advice to government is not a ground for refusing to disclose it. Again, some harm to the public interest must be established, such as prejudice to legal proceedings, disclosure of Cabinet deliberations, or prejudice to the Commonwealth's position in negotiations. Any general claim that advice should not be disclosed is defeated by the frequency with which governments disclose advice when they choose to do so.
I think when decisions are made, there are a range of processes which can be involved. I think I'd need to take on notice.
Yeah, I didn't ask you about the processes. I'm just simply asking you, has it got to the Cabinet table? I mean, you've had 2 years. I just want to see how serious you are. How many people in the department have you had working on this now since the first reforms at the end of 2023? How many have you had working on this? Because it's so important. It's really important, the Whistleblower Protection Authority. How many people have you had working on this on a day-to-day?
I can speak to how many people I currently have working on it. I can't...
Currently since when? What, are you just been rushing on because we had this? Has this just happened in the last week? We just had a blow in and go all quick up the numbers? We know how it works. I've been up here for too long. So maybe if you could get that. I'd also like to know how many people actually work in the Attorney's office. Are you contracting out at the moment? This I'd like you to answer now. Are you contracting any of this Whistleblower Protection Authority? Are you putting that out to consultants? Are you paying any consultants at the moment to help you with that Whistleblower Protection Authority, the Stage 2? All the next stages?
The department is leading the policy work that relates to consideration of Stage 2.
That's not what I asked you. I asked you if you're using outside involvement. Are you using consultants?
We're not using consultants.
You're not using any other law firms to assist with this?
No, this is...
Okay, not consultants, then let's go law firms, because they're consulting you. Let's use it properly. Are you using other law firms to help you with the Whistleblower Protection Authority, and who are they?
We are not using law firms. We have gone through a public consultation process. A range of stakeholders have provided input. I have approximately 8 staff currently dedicated to whistleblowing related reforms.
And could you please provide the committee with the stakeholders that you've been speaking to, please? Or you can announce them now. What stakeholders have you been speaking to?
So the submissions were all public.
No, besides the submissions, nice one. What other stakeholders have you been talking to?
We have been engaging with stakeholders that were part of the public consultation process.
So what other interests have you been speaking to? Let me reread that then. What other interests on the outside of those submissions? And if you're not giving any of this stuff out to other law firms to do the work on, who else outside of that have you been speaking to about this Whistleblower Protection Authority, Stage 2 and further on?
consultations are being undertaken with government agencies that would be affected by reforms. So that would include the Ombudsman Commission and IGES. We've also had periodic meetings with representatives from Transparency International and other parties who have made submissions to this process. And so the consultations that have occurred are with government agencies, and we've given consideration to submissions that have been made as part of the public consultation process.
Ms McKay, I'd like you to take that question on notice, and probably rethink what you've just told me, and then come back with who else has been involved. So I'll leave that with you now. How many cases does ASIC have on its table right now?
We would have to take that on notice as well.
And how many people do you have working in the department?
On the whistleblowing review, we have 5 people at present working on the review directly.
And are you using any outside resources at all?
No.
Okay. Can I... So I want to know how, have you come up with any conclusion on how you're going to make sure that whistleblowers feel safe coming forward, and that's both of you? Because quite frankly, you obviously don't have anything set up on the sideline of psychology or anything like that. What do you do with those whistleblowers? You just go, thanks very much, just sit on the sidelines? When do you do welfare checks? Tell me about all that stuff. When people come forward and they have complaints, let's say to ASIC, what welfare checks and that have you got in place within your department, right? Especially if they're up against big corporations, what are you doing to assist them in that care, health-wise?
So, if I can just go back a moment, Senator, with respect to ASIC's management of the claims, I understand they gave evidence earlier about the engagement of psychology services, apologies if I'm mistaken, about that, and their systems in relation to the management of whistleblowers and so forth are something that they've been evolving over time, and I'm sure
Evolving. So you'll have a list of that. You've got a checklist, have you? A checkpoint that can you supply that to the committee? I'd like to see what you're telling them and advising them when they come and blow the whistle on where they can get further help from. So if you can provide that to the committee, do you have one of them now?
I don't have one of those now. I would have to take it on notice, but I'd also suggest that perhaps these questions ASIC might be able to weigh in on a bit more fully.
Okay. That's it for me. Thanks, Chair.
Senator, did you have a follow-up before I go to... Yep, before I go to Senator
Just
Foley.
on the second tranche of PIT Act, what date was that advice provided to government?
I would have to take that on notice.
Okay. Thank you.
Are you done?
Thanks,
awesome. Senator Polly.
Thank you, Chair. I just wanted to follow up with some questions. In 2023, the Albanese government Stage 1 public interest disclosure reforms were passed in time for the commencement of NAC. So how many of the independent statutory review recommendations were implemented in the first tranche of reforms? Can you advise us on that?
Thank you for your question, Senator. In terms of the MOST review recommendations, 21 of 33 recommendations were acquitted as part of Stage 1 reforms. In addition, Stage 1 acquitted a number of recommendations coming from other processes, including the Parliamentary Joint Committee on Intelligence and Security inquiry into the impact of the exercise of law enforcement and intelligence powers on freedom of the press, and also two recommendations from the Parliamentary Joint Committee on Corporations and Financial Services inquiry into whistleblower protections in the corporate, public and not-for-profit sectors report.
Right, so if we move on now, and you've covered some of this, but the the department undertook public consultation on stage 2 reforms, which included asking the merits of Whistleblower Protection Authority. And did the department receive mixed views on whether a new standalone authority should be established rather than providing some of the functions to existing integrity agencies such as the Commonwealth Ombudsman? Because I'm sure you're aware of the evidence today that they're already doing some of this and they could do more if they were better resourced.
Yes, there were mixed views received with respect to submissions as to the need for establishing a standalone whistleblower protection authority.
Was there any concerns raised about the oversight body also providing an advocacy for legal advice role in the terms of the risk of perceived or actual conflict of interest? And if so, can you please just step us through those concerns? Again, I think we've had some other evidence, but I'd like to hear what the department has to say.
I think it is something which the department would suggest is an issue in the current model, in the sense that the co-location of regulatory and oversight functions together with advocacy functions for individual whistleblowers is something that doesn't typically sit in the same organisation. I think that you've heard submissions this afternoon from the Ombudsman and also the Australian Human Rights Commission as to the reasons for that, and I would support those submissions. I think it's something, and I'm not an expert in space, but that was also given consideration as part of government's response to the Set the Standard report. And so, for example, the Parliamentary Workplace Support Service and the Independent Parliamentary Standards Commission performed different functions. So I think better practice would be to keep those functions of oversight and advocacy separate.
So some of the submitters to this inquiry have queried whether it's appropriate for the authority to base the structure around NAC legislative framework. Does the department share these concerns, and if so, why?
I think in giving consideration to powers and functions of a body, those considerations are always approached on a case-by-case basis, and the rationale for particular powers being exercised needs to be given due consideration. I think particularly powers of the nature of those held by the NAC. So I think it would be something that would need to be considered, and I think, again, others have spoken about that this afternoon.
Can I then go, I've asked questions and others have asked questions around the cost. Now, one of the key issues is whether there is demand to justify the cost of setting up an entirely new agency. What's the department's view on the number of public interest disclosures that are made and whether this justifies the cost of a separate agency?
I think the Ombudsman Commission in its report reports publicly on the number of public interest disclosures, and they're already part of its function. I think as a general principle, government would give consideration to the cost of setting up an additional standalone body, noting that there are existing agencies that exercise a number of the powers currently ascribed to the Whistleblower Protection Authority.
Does the department consider that national security information will be properly protected under the bill?
I think national security protected information is protected under the PID Act and is oversighted. Intelligence disclosures are oversighted by the IGIS. It's not something that is clear from the current bill how that would be protected, so it would be an issue that would need to be given due consideration.
Does the department have a clear sense of what the core terms in the bill mean and how the authority would interact with the Public Interest Disclosure Act and existing regulatory and oversight bodies?
I think there would be need to work through how this new body would interact with the PID Act.
And I've asked this question to a number of the witnesses, and that is, are there any issues that are different that whistleblowing, when people come forward from the public and the private sector, are there differences that should be considered for an oversight body, and will this bill address those issues?
I think there are differences in the accountability frameworks that apply to the private sector and the public sector. The PGPA Act sets up particular accountabilities having regard to agencies spending taxpayer money. The accountability frameworks in the private sector under the Corporations Act are quite distinct, and so also the nature of disclosures, and so separate regimes have been developed in response to those different contexts, as we've identified earlier. To the extent that it can be done so, we are looking for opportunities to more closely align those frameworks to support whistleblowers and make the frameworks more accessible. But I think, there's often very sound contextual reasons for why legal frameworks can differ across sectors.
Thank you, Senator Polley. I'm going to need to share the call now. I've got a couple of follow-up questions. I'll go to Senator Pocock and then Land.
Thanks, Chair. And sorry, just to come back to the timing of advice, I just know that whenever we put these in as quans, often departments come back with some sort of vague thing or just don't answer them. And so I'm just interested, like, date range, was it given before the election, since the election?
I can speak to that briefly. We've provided advice at various points with various degrees of formality. So, initial indication of how many consultation submissions were made was obviously a very early piece of advice post the consultation process, and more substantive advice at various points throughout the process. But
so substantive when?
Dates on.
Sorry.
We'll take the actual dates on notice.
But I'm just like date range. Have you provided substantive advice in the last Parliament on Tranche 2?
Advice has been provided to government in the last Parliament.
And in the new Parliament, have you provided further advice on Tranche 2?
To the extent that the new Attorney-General was briefed on the role of the department and its current priorities.
But that was including kind of the old advice that was provided to the former Attorney-General, Mark Dreyfus.
I think we'll come back to you on dates.
Of
I can take that question on notice.
This is surely in your wheelhouse. Is there more PID Act Tranche 2 advice to go to government, or has the final advice been provided to government?
I can't comment on advice that may be provided to government
No,
in the future or not.
you can, unless it is prejudicing the public.
It's pretty simple. Do you have further advice that you want? We don't want to. We're not going to ask you what the advice is. Do you or do you not have further advice for the government? We'd like to see how close you are to finishing this, I think.
Or have you've given them advice on tranche 2 of the PID Act?
I think what I can say is that the government is committed to stage 2.
No, we know that. That's for the government to say. You're in the...
Let's have one person ask questions at a time rather than the tag team. Sorry, Senator Lambie, I'll let you finish your question, Senator Pocock.
I'm happy to take on notice the dates that advice has been provided to government.
And what about whether or not you've provided the department's sort of final advice on tranche 2 of the PID Act?
It's not for me to provide details of the nature of advice that has been provided.
According to the standing orders, you are well within your rights as a public servant, the people of Australia, to provide that advice to the Senate.
I'll take on notice what further information
Sorry,
I can provide.
because you don't know, or you think that you may have to claim PII? A genuine question.
I think I'll take on notice the question.
Suggesting they'll take the question on notice, and it's within their right to take a question on notice.
That's appropriate.
And to see where they can get back to you.
Okay, thank you. I appreciate it.
And then if we're not getting the advice that we require, Chair, are you bringing them back? Because this is what happens every time, and they get away with this stuff. This is what we're sick of.
She's taken it on notice.
Yeah.
And I'm asking her what's happened, Senator Polly.
And I think...
Thank you.
We'll see what advice we get back from the officials, and we can follow up if needed. I'm happy to have a conversation about
If you want to complain about and you think I've got harassment, please put in a complaint, Senator Polly, because that's rubbish.
I think we will leave that there. But I think
Thank you.
Senator Lambie, did you have a follow-up question or no?
No, that's been done, thanks.
Okay.
Thank you very much.
All right.
Thank you for your time.
Thank you very much, and I want to thank officials for appearing before the committee today. If you've been asked to provide any additional information, which you have, would you please forward it to the Secretary by the 21st of August 2025. You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to any transcription errors. Thank you very much. That concludes today's proceeding. The committee has agreed that answers to questions on notice, as I said, be returned by close of business on the 21st of August 2025. I want to thank witnesses for appearing today, and particularly whistleblowers who appeared before the committee today. Thank them for their perseverance and courage in continuing to come forward and to give evidence. And thanks to Broadcasting and Secretariat. I declare the hearing adjourned.